ಇದೊಂದು ನೈಸ್ ಆನ್ ಮಾಡಿ.
Surfactants is you are basically surfactants. My lords, a matter for end of list, my lords.
What is that?
So it's a notice has been issued to vacate the premises, my lords. She has not defaulted the loan. The petitioner has not defaulted.
Use the mic.
Petitioner has not defaulted the loan, my lords. Only default is the insurance premium, my lords. That they have issued the notice on.
Respondent.
Respondent is HDFC Bank, my lords.
Who appears for HDFC Bank?
My lords, it's a fresh filing, my lords.
Who appears?
Pradeep.
No, that is bank. You appear?
I'm for the HDFC.
Yes, whenever it is, if it is before I raise, if the matter comes, I'll take. Before that, you serve the papers on him, he'll get instructions.
Please, my lords.
Yes. Call the list.
Page-wise adjournment, list number 1, page number 2, serial number 4 to 7.
My lords, list 1, serial number 5, my lords.
Yes.
I'm for petition this case, my lords.
Who has moved the memo?
Respondents moved it, my lords. We have not moved it.
Then how can you make a mention?
My lords, they just.
We
My
will
lords,
see.
no.
Item number 5.
Office is fully flooded.
We will see.
Office is fully flooded, my lords.
Whatever it is, we'll see. Please wait.
Page number 3,
Yes, my lords.
serial number 8 to 10.
Look, serial number 9.
Hmm.
I moved the matter. I'm for the petitioner. It had been referred for mediation, my lord, on 3rd February. There have been about 7 sessions of for 5th of May. The mediators told us that we have to seek an extension from this honorable court. Hence, my lords, if an extension may be granted.
9. Land Council.
Respondent, we are appearing for the respondent. My lord, they have an alternative remedy, my lord.
My lord, that's on the merits. Parties are exploring
What about
settlement.
an alternative remedy? It seems there is a scope for mediation, settlement.
It was referred, my lord. And there
So,
are 8th session is
anyhow,
on 5th.
vacation, we'll wait till June. The Land Council for the petition service, sir. Matter is already referred to the mediation. And in view of the time fixed by the court. Now they're going to send back the file to the court. It is submitted that there is scope for mediation. Accordingly, the time that is granted earlier by order dated, look at the order, is extended. And extended if the if there is no if it is not fruitful, the matter shall be sent back to the court by 5th of June. Yes, next.
My lord, there's an interim order.
5th of June, I said.
My lord, there's an interim order in serial
Interim
number
order
9
earlier
and
granted is
9.1.
extended. Yes, next.
Page number 4, page number 4, serial number 11 to 16.
My lord, serial number 16, the appellant counsel, Ms. Renuka, is hospitalized, my lords. She informed me in the morning. Date may be fixed after vacation.
This is matter after vacation.
Obliged.
Page number 5, serial number 17, 18. Page number 6, 19 to 23.
With the lordship's kind leave. Serial number 23. In the first matter, I beg to appear for respondent number 1. The second matter, I am for the appellant. May I request your lordship to kindly have it after vacation?
Yes, after vacation.
Highly grateful.
I'm serial number 22, my lords.
Yes.
I'm appearing for the respondent, my lords. On short accommodation, my lords. He has some personal inconvenience.
Serial number
It's a insurance company's appeal. Let them
Yes,
argue
please, we are appearing for the owner, my lords.
after vacation.
Serial number
Between
19.
you and between the insurer and the owner, what will happen to the claimant?
No, my lords, after vacation, we.
Yes.
Serial number 19. I appear for the respondents. I have informed the other side as well, my lord. Today there is some
Why
inquiry.
are you seeking adjournment in their appeal? That I'm not able to understand. 2013.
My lords, today
Are you for the
machinery is
claimant
not-
or for the owner?
My lords, I am the contesting respondent. I am the owner.
You are for the claimant. Just wait. Let them argue. If the court, if it is required, then I'll adjourn. If there is no point, I'll dismiss the writ petition appeal. Right from 2013, the claimants are not having the money. Yes.
page number 7, serial number 24 to 27. Page number 8, 28 to 29.
Serial number 29, my lords.
20.
29, my lords.
Oh.
I'm after vacation because the liability is absolved against the insurance company.
I want record from the company. So far, I have not received records minutes after vacation.
No, we just see. If required, we will adjourn the matter.
Some liability is not there, minutes, so that's why minutes.
No,
I also.
why are you presuming that now the liability will be fixed on the insurance company?
I do policy terms.
If at all the court wants to fix the liability on the insurance company, then we will adjourn.
I don't have any papers, minutes.
We'll see. Yes.
Page number 1.
After
for
vacation,
orders.
minutes, I am not ready. That's why I don't have any papers.
That's what I'm saying. I'll not pass any adverse orders. I'll give you an opportunity. Please wait. Yes.
Page number 1. Serial number 1 for orders matter. Nagar 38.
Yes, memo for withdrawal.
Memo of withdrawal.
It's there, I guess. It's not there. It must be there, and it is there in the mentioned in the process. Take it from in then. A memo is filed stating that the matter is amicably settled between the parties and it's nothing suffice for consideration. Accordingly dismissed as infractious. Yes, 2.
Serial number 2. Manoj K.
The limited issue is whether I am covered under pronits or not. I had given my lords a list of dates because from the time I was treated as NPA, consistently I have taken a stand that I am covered under pronits. I am entitled for the benefit of the restructuring and moratorium as per the RBI guidelines. Lordships directed because we submitted two things, my lords. There were two demand notices under 13.2. One was out of mistake perhaps because 90 days had not lapsed as on the date when they issued the first notice. After they issued the first notice, after giving a reply, I came before this honorable court for only one reason. The only reason which I have come before the court is saying that I am entitled for restructuring. They are not extending the benefit of restructuring as per the RBI guidelines. When that repetition was pending, they realized that that notice cannot survive because there was no NPA as on that date. Factually, there could not have been an NPA. So they issued a second notice in the month of August, for which I gave a reply. They wanted to say that this reply statement is not with us. Your lordship specifically directed them, say that it's not part of your record and it's a fabricated document. It so happened that the possession is already taken over by them so far as my residential property is concerned. Now, I had some, there are medical emergencies because he is under some medical care, including his wife. They are in the old age. We requested them and we could get one of the letters or the same letter. Two letters were given, same letter. One was given by the staff. The other one was personally handed over to the person who was in charge of this. We have that letter and the acknowledgement is also there with us. If they open, I can easily pull out that original letter and give it to them. But what they have not done is they have not filed an affidavit as per your lordship's direction as to whether or not this is a fabricated document.
When was that order?
I'll just point out. Order sheet. Yeah. At that is on 18.3.
18?
18.3. Uh, 6.3 minutes. Specifically on 6.3. And then again on 19.3, your lordships have. Now, as per your lordship's directions dated 18/3/2026, I have deposited 50 lakhs.
Yes.
But still now it is not there. I've now got this.
Yes, Mr. Vignesh.
Let them file an affidavit that this is fabricated. I will demonstrate, that the bank is not been fair to me, is what I can say. I have got a series of, because after these things transpired, we have unearthed whatever communications was there between myself and the bank. It is not one communication. From the month of February, when I was not yet an NPA, requests has been consistently made virtually every month, either to restructure it or to reschedule it as permissible under the RBI guidelines. Then they sent a mail saying that we will not extend this benefit to you in the month of September. We will not extend this benefit to you because you are due in a sum of so and so. I seek for restructuring only when I am due. If I am not in due, why will I seek for restructuring? That's the kind of cases which is covered under RBI guidelines. So they have communicated to us saying that we will not extend this benefit because you are due. But as I submitted earlier, my lords, they even said that so far as interest is concerned, let them say that.
Committee is constituted.
Committee is there, my lords.
No,
The
no, it's
bank is-
constituted in your case.
No, lords, in my case, consistent mails.
According to you.
No committee. It is not placed before the committee.
Before issuing, declaring an account of an MSME as NPA.
Yes.
What is the procedure to be followed?
Lords, now in view of the pronits and the subsequent judgment, at the time when they issue 13-2 notice, I will have to bring it to their notice that I am an MSME, I am entitled for the benefit of the restructuring in terms of the 2005 circular.
The circular reads otherwise. If you look
Lords,
at the
but this,
circular,
I understand, my lords, pronits case, I'm sorry, the circular says, even before my account is treated as NPA, it should be done.
the Supreme Court judgment also cannot be contrary to their circular.
That is true, my lords. Now, they never undertook this exercise. The reason why I am submitting this is, the
As per the
NPA,
circular, what should they do?
lords, as per circular, before treating it as an NPA, they will have to place it before the committee. Prior to that date, my lords, if I have brought it to their notice, if it is a question, my lords, I have got ample documents to show that.
I think in Pronit's case, it was only decided, it was only discussed or observed about what should happen after 13.
After 13-2. After 13-2, here is a case, my lords, we have crossed that stage of 13-2, they have gone to 13-4. Between 13-2 and 13-4 is the contingency with which we are now faced. Their pronits specifically said that if after 13-2, if I have given a reply, they are bound to place it before the committee, otherwise they cannot proceed under 13-4. That's now the difficulty, my lords, for us is that this is a residential property. 50 lakhs we have paid. If your lords were to put us on further terms, my lords, let them give back the position. Lords may treat it as parted and have this matter immediately after vacation, my lords.
My lord, there are two writ petition. My lord, I am representing, my lord, the second writ petition number 6302 of 2026. First writ petition. Lord, kindly come to, my lord, the prayer sought before this honorable court at, my lord, page number 20, page number 21.
Use that.
18.
First writ 6302 of 2026,
Next one.
which we filed, my lord, detailed objection to, my lord, the writ
Photo
petition.
there.
One.
You're referring to 188.
163, no, my lord, 6302 of 2026.
That's
My
the first
senior-
writ petition.
I'm so sorry, that same writ petition which I. My lord, prayer sought is, my lord, at page number 21. The first prayer, my lord, at page number 22A, issue a writ order or direction in the nature or certiorari any other appropriate writ declaring that actions of the respondent bank classifying the account as petition as NPA is bad by law. Second prayer, my lord, to quash, set aside the auction sale notice dated 13/2/2026 issued under section 13(4) of SARFAESI Act and quash and hold virus and declaration of the petition's account NPA. My lord, they sought, my lord, three relief before this honorable court. My lord, what had happened, my lord? The petitioner, in fact, my lord, kindly take my statement of objection which I filed before this honorable court, including, my lord, from the date 1, when I sanctioned the, my lord, the loan in the year of 2017.
No objections.
I sanctioned the loan on, my lord, 16/3/2017. 16/3/2017. My lord, kindly get, my lord, in fact, my lord, yesterday when some other matter was arguing, my lord asked one question. It is a MSME loan. My lord, I'll just clarify, my lord, what is, my lord, from above 1 crore up to 250 crore. all loans except my lord housing loan or other loan, my lord, all coming under the definition of MSME. My lord, it is not that, my lord, it's a term loan. Or, my lord, in this case, my lord, if you, my lord, kindly see the sanction.
What is it? What is meant by MSME?
MSME means, my lord, under the, my lord, Act, the transaction or turnover is above 1 crore, up to 5 crore, it is micro. Above 5 crore, up to, my lord, 50 crore, it is small. Above 50 crore, up to 250 crore, it is medium. The MSME guidelines will applicable from 1 crore to 250 crore. It is, my lord, settled position of law. In this case, my lord, every day, my lord, we are MSME loan, MSME. It's not MSME loan. It's, my lord, it's either, my lord, cash credit or term loan or based on the property loan. However, my lord, they are coming under less than 250 crore rupees, my lord, turnover company. Therefore, they can classify, my lord, take it as MSME. That is not in dispute. Now, there are certain guidelines, my lord, which I agree, my lord. In fact, my lord, every day we assist this honorable court in respect of 2015 notification RBI, wherein, my lord, subsequently, my lord, in the case of Pronit, my lord, where, my lord, the committee has to be formed, whether insufficiency test has to be, my lord, either, my lord, bank or, my lord, the petitioner has to, my lord, inform, my lord, and committee has to form.
So, right, every time you argue, the only query of the court is, whatever as per the circular, you have to do something for declaring it as an NPA. What is that the bank is doing? That is what I want to know.
In this case, they are not.
On its case will come after 13-2.
Please.
Before it, what you have to do? You have to do something.
In fact, my lord, other day which we pointed out, either, my lord, they have to give a request, which we wanted to restructure or, my lord, revive the company, or one second tabular says that, my lord, either insufficiency I can find out and I can place before the committee. That is there, my lord, in fact, which we pointed out. In this case, why that is not going to applicable? I just pointed out. My lord, in fact, my lord, there are 4 loans they availed. One is, my lord, OCC, one is, my lord, term loan, and one is GL. And I classified the account as NPA. My lord, my lord, kindly come to the, my lord, demand notice which I produced at, my lord, page number 54, annexure R6.
Dated?
My lord, 22/8/2023. Before that, my lord, earlier also my senior counsel is rightly pointed out. I should earlier also demand notice. That is at, my lord, page number 48.
Give me the dates. Demand
1/7/2023.
1/7/2023. 23 is the first notice.
First notice.
It is at page number?
Page number, my lord, 48 of my statement of opposition and SARFAESI.
When is the next notice?
My lord, subsequently, my lord, they given a request saying that, my lord, we are giving, we are going to overdue amount, and, my lord, we are given an opportunity. They are not complied. Again, because in respect of demand notice, my lord, there is no bar, my lord, it's just demand. I can issue, my lord, in the case of, my lord, Dowji Pharma versus Bafna, the Dowji Pharma judgment versus Dena Bank. The Honorable Gujarat High Court held that, my lord, bank have all the rights to issue a number of demand notice. So, my lord, that cannot be find any fault in this matter. I should once again demand notice at, my lord, page number, my lord, 54, dated 22/8/2023. 22/8/2023. I demanded rupees, my lord, 10 crore 16,44,785. My lord can find it at 10 on 22/8/2023. I demanded, my lord, 10 crore 16,44,795. In fact, my lord, I indicated when account became NPA, everything, my lord, I indicated in the notice.
Then is it your case that to the demand notice dated 22/8, you have not received any reply from them?
My lord, from the day one, my lord, I'm making this submission. In fact, the first day matter came before this honorable court. This honorable court asked me a question, whether you are considered their reply. I pointed out, my lord, kindly see that, my lord, there is no seal and signature. In the bank, it's fact, my lord, nothing to laugh in this matter. In fact, we made this submission before the honorable court.
In your objections,
Please, my lord.
objections, which is filed subsequent to this order.
Please, my lord.
What did you say?
In fact, my lord, kindly come to.
My lords, I just take an exception to what my learned friend says. We have produced 3 communications from the bank. From the bank. Lords, to the first notice dated 1/7, 10/8 is the reply. Lords, to 10/8, on 25/8 they have given a reply for this MSME restructuring. Now what they said is that your letter dated so and so.
That is at page number?
Lords, this is filed along with a memo.
Memo dated?
Memo dated.
My lord, in fact, I produced.
6-3, memo dated 6-3. This is a communication dated 25/8. You produced, my lord, 25/8.
No, 25 ಅಲ್ಲ 10th August 2023 I produced in my statement.
10th August 23 we had produced. 25/8/23. That's why should I withhold? I really don't understand. These are all the documents which is forthcoming from their records. They should be fair. They should just produce all the communications to indicate that I'm not entitled for the relief. There ends the matter. On the memo dated 6/3/2023, we produced it.
My lord, kindly come to my lord page.
Then after that, they have issued a demand
After
notice
that,
on
not,
6 to 8.
that's a wrong statement to be made saying that there was a second demand notice. It is not a second demand notice. The reason is,
Where
what?
is that 20 to 8? Let us see.
Not 22/8 is the 25/8 minutes is along with the memo dated 6/3.
No, he has also in this compilation also it's there. Where
No,
is
he has not filed it.
Which one?
You said you're referring to 22/8/2023.
25/8.
No, page number 54 in statement of objections.
25/8/23 is their reply.
No, it's a demand notice under 30.
That's 22/8 is the second demand notice.
That's what.
Is what he says. But I would say it is a first demand notice for the reason that 1/7/2023 when that in demand notice was issued, what transpired was that the EMI was paid up to the end of March 2023, 31st of March 2023. This was paid on 36/2023. So from there, this 3 months would not have lapsed as on 1/7/2023. So that they realized that there is no way that they can treat this as an NPA. There are two different dates given for NPA in both the notices. You cannot make a statement that second different dates are given, and that's rightly done. To the first demand notice, which was issued when my account in fact was not NPA, we gave a reply on 10/8/2023. For that, they have issued a reply on 25/8/2023, saying that you are asked for restructuring of the facilities. These are all the loans which are there. They said that we extended this benefit during this COVID pandemic up to 2021. Restructuring we permitted. Now also you to help you to overcome out of the present hardship, bank has come forward to restructure your account. This is on 25/8/23. 22/8/23 is the second demand notice. I am referring to 25/8/23 communication by the bank.
Let's see that.
That's memo dated 6/3 minutes. Should keep it along with the memo. How will I?
That's not their case.
Let's see.
Idot copy idya. Ido.
Like, is it filed as some synopsis?
It is just filed along with the memo, two documents minutes. One is the reply dated 10/8/23 and this 25/8/23 reply by the bank, and 25/8/23 which we gave it as a reply to their 22/8 notice. Yeah, one more copy. Check. Can I just pass this on minutes? I have only one copy. The court cannot. I'll just assist the court officer minutes to find the copy. My counsel on record will assist.
No, there is something. One memo is on 4/3.
4/3. Sorry, minutes.
It shows the letter dated 25th August 2020.
Yes, 25th August 2023.
Let's
That's
see
by
what
the
is
bank. The bank says, Lords may kindly see what they have done.
So this 25th August is a reply to
the
8.
10/8.
Let's see
Lords
what.
1/7.
No, before that we'll see 10/8/2023. What is the reply?
Lords 10/8. Lords will have that. Lords 10/8 is the previous page itself. Lords in the same.
In fact, I also produced in the statement of objection.
You have filed?
I filed at page number
Page
169.
number?
169 of statement of objection.
Lords, Sorry.
And my reply, my lord, at page number 171.
One?
71.
Page
You can put it
169, in their statement of objections, annexure R13. And 25(8) is page 171. My lord, sir.
Let's see first this.
Please.
Then your reply will be.
Now, Lords, may kindly see, reference to the above, wish to submit the following for your consideration. We are in food and beverage industry, an SME.
Yes.
Founded by a professional agri supply chain expert having an so and so in then we speak about the para 4 that EMIs are payable so and so. It did not resume the operations after the lockdown. We have been representing both in person so and so to extend the loan tenure to make the EMIs more manageable and line with the business turnover, but of no avail from your response. This is in line with what is said in the 2015 guidelines. After this, consequently, your above referred notices have been issued to us. Notices not only elaborate on the consequences and penal actions that may be taken against us, but are also bound to cause severe disruption. Further, your letter dated. So ultimately, Milords, we asked that we wish to submit that the working on the same needs a minimum of 4 months. Mobile clear OD, regularize the account, or making efforts of clearing entire loan, close the account. We are seeking time till 31st of December. In view of the above present situation, our intention to clear the overdues entire loan, we request to put aside, defer any actions in the SARFAESI so that the business can continue to be carried, positive resolution can be arrived, etc. To that response, Milords, page 171 in their statement of objections. Lordship gets it, Milords. Milords, after the tabulated column, during COVID-19 pandemic has supported you by sanctioning so and so. Moreover, bank is also time and again supported by way of restructuring the accounts during August 19 and additional term loan. And subsequently, during June 2001, second restructuring was done as per your request, taking into consideration difficult situation. Now also, to help you to overcome out of the present hardship, the bank has come forward to restructure your account. However, the restructure can be implemented once you clear the outstanding dues on that date. As per the letter number so and so 4823, we have communicated you have to restructure your account once you clear the dues. As you have not come out with a definite plan to clear the overdues, we have initiated a recovery action.
Mr. Vignesh.
Please note the recovery action is initiated. We are not in a position to consider your request.
No. Is it not sufficient to refer it to the committee?
No, my lord, I'll just point out, my lord, my lord, my senior wanted to say something in respect of his repetition, then my lord, I'll answer.
My repetition could be infectious because subsequent notice has been issued. But one thing I would like to bring it to the notice of the court is, my lord, the fourth loan is a GCL loan. The fifth loan is a WCDL loan. The loan has been restructured. Now, subsequent to restructuring of the loan, COVID benefit they have taken. The question of whether MSME benefit for an account which has already been restructured has to be considered by this court. Right? It cannot be done.
Considered by the court, whether it is permissible or not, you have to tell the court. Is it your case that?
It is not, because I tell you, my lord, the reason why it cannot be is once the restructuring of the account is done, it is downgraded from standard to substandard. Then after 1 year, if they continue to pay the loan dues and they then repay the loan with interest, then their account gets standardized. Only then the question of benefit of MSME will arise. Here is a case subsequent to the account turning after restructuring, they got.
No, we have to understand. No, we have to understand whatever you are submitting, basing on some guidelines, some circulars.
Yeah, this is RBI guidelines.
Let us see that.
Yes.
Let us see the RBI guidelines pertaining to MSME. Take that.
Same 2005 guidelines.
Page 49. This is the page 49.
Link statement of objections, sir.
RBI guidelines. Page 49.
Yes.
This is the paragraph 17. Asset classification. In case of restructuring, the accounts classified as standard shall be immediately downgraded as non-performing assets, that is substandard to begin with. The NPA upon restructuring would continue to have the same asset classification as prior to restructuring. In both the cases, the asset classification shall continue to be governed by the aging criteria as laid out in para 8. The para 8 is that in pronate's judgment, you get those three categories.
Correct.
So 30 days, 60 days, 90 days, then declare it as NPA. Now, well, this account is NPA. Then subsequently, I'm told they went to the NCLT and they have spent time there. So where is the question of getting the benefit of MSME account when their account has not been again updated at all? It cannot be, the benefit itself cannot be granted. That's the first thing. Your Lordship was asking a pertinent question whether who has to, when it's an MSME account. It is the borrower who has to inform the bank that we are going to entering into a situation where the account will turn NPA. Give us the benefit. If your Lordship may look into Swami Samar's judgment.
In this case, yes, when you have given a notice, demand notice under 13(2), in that reply process, he has already submitted to you.
My lord, in my case, it might have been withdrawn, my lord. In my case, it might have been withdrawn. But that was the first opportune moment. Once he loses that, it might have withdrawn. But he did not seek for a...
No. When he brings it to your notice, this is what it is. It is not for you to take a decision. You have to constitute a committee as per the Reserve Bank guidelines.
No. In my case, I couldn't because it was already restructured.
When it comes to his case, they have to do it.
No, my lord. There also, if your Lordship may look into Swami Samar's judgment.
Let us not go to the judgments at all. Let us look at your own
circular. If we do not go for the judgments, my lord, then if the notification clearly says, notification 13(2) opportunity.
No, they are fulfilled.
Prior to 13(2).
That is not for your chief manager to say that whether you are entitled for restructuring or not. As per the circular, that has to be,
committee.
You have to constitute a committee. Committee has to take a decision.
That is true.
Whether a committee has been constituted in this case is the issue, which is not. So, when you are bound to follow a circular, why you independently take a decision?
If the benefit is available, if the account was standardized, only then, my lord, he is entitled to seek for MSME.
Does your circular say so?
Yes, my lord.
MSME. No, we don't have to read it in a piecemeal. First, at the stage 1, before 13(2), when you issued a 13(2), he came before you and said that I'm an MSME, I'm having this. Please consider this. No, it is for the committee. First of all, you have to constitute a committee. Place it before the committee. Committee will decide whether he is entitled for it or not.
I'll answer to this, my lord. The entire case of the petitioner is page number 127 of in the writ petition, the present writ petition which I am arguing. My lord, kindly come to the letter dated 25th August 2023. At my lord, annexure Q, page number 127. Which, my lord, the first day when I disputed this document because there is no seal and signature. Earlier documents, which, my lord, in fact, my lord, page number 169.
Which document you disputed on the last occasion?
Page number 127, annexure Q. In fact, I filed statement of objection on that effect.
Just dated.
Dated, my lord, 25th August 2023. That's the only communication or letter my senior counsel is harping, saying that they would have considered. In fact, it is not. They are not entitled. That is different aspect. That, my lord, kindly come to 127 for a moment. 127 in the appeal memo, in the writ petition.
127
of their in the writ petition. Letter dated 25th August 2023.
Yes.
My lord, I'll draw my lord's attention at page number 169. That is R13. Again, my lord, statement of objections. There one more representation, which, my lord, you duly considered. It's not in dispute. No. Why I'm trying to say, my lord, this which I disputed.
It's difficult for the court to go switch over from here to there.
My lord, this letter we disputed in my statement.
Sir, which letter? Which page?
Page number, my lord, 7 of my statement of objection, paragraph number 6.
Yes,
I disputed that document.
Yes.
The petition alleged that Respondent Bank not considered the restructuring proposal submitted by the petitioner. The allegation regarding a violation of section 13(3) of SARFAESI Act is also incorrect and denied. It submitted that after issuance of second demand, that should be fresh demand notice, my lord, on dated 22/8/2023, no valid representation or objection was received from the petitioner requiring consideration under section 13(3)(a) of the Act. and therefore the question of non-consideration does not arise. When the petitioner failed to comply with the terms and conditions stipulated in the letter stated 3/6/2023 and 4/8/2023, the respondent bank issued a fresh demand notice on 22/8/2023 under section 13(2) of SARFAESI Act, which was duly served upon the petitioner. The respondent bank had earlier considered the petition representation on 10/8/2023, which I pointed out just now.
So,
And informed, just complete.
please wait. Now, you accept that this is with regard to this representation dated 10/8/2023,
Which I
is
received.
rejected by you saying that unless and until the overdues are cleared, you cannot restructure the account. Now, whether it's, can you give such a reply dated 10/8/2023?
Lord, the language, Lord, I can. Lord, in fact, they're accepted. That's what my respectful submission in the writ petition. They came to this honorable court. There, I'll just point out the order. Lord, I'm not saying anything, my Lord, on my own. That the honorable court passing order. I'll just point out that for a moment.
No, the resolution says prior to the account turning NPA, they have to approach. When the account is NPA, my Lord, there is a question of we telling them if the account is standardized, then we should intimate them.
My Lord, kindly
It
see
is
the order
NPA.
dated.
It's an NPA account.
Kindly see the order
I'm
dated.
only trying to understand the procedure, isn't it? I'm only trying to understand it, the facts. It is nothing to do with, there is no argument on this. I'm only trying to understand what is the procedure, what has been done, whether it is in consonance with the circular or not. Now, 10/8/2023 through a 13(2) notice, he has given a reply dated 10, that is 10/8/2023. The notice is dated 1/7, demand notice is dated 1/7/2023. He gave a reply which is admitted. In the reply, he said that I am an MSME, I have all these issues, please restructure my loan. In that case, where is a question of you replying to that? What you should do? You should constitute a committee. Have you constituted or not? After that, what did the High Court say? What did you do? Doesn't matter.
Lord, in case, Lord, he says, give me some time. He issues a representation.
No, he asked for restructuring of the
Let
loan.
us presume, my Lord, he says, give me some time. My Lord, for that, I need not reply. Even if I don't reply, my Lord.
Not required.
The
Don't
same
reply.
way, my Lord.
You don't have to reply.
The same
You
way.
have to constitute a committee.
The Supreme Court judgment clearly says, you don't have to, even if he has not sought something material, if he is subsequent to issuance 13(2), 13(3), if there is nothing substantial or material, you don't have to reply, and it will not be fatal to the bank's interest. Here also, my Lord, since it is an NPA account, I don't have to reply. If I don't reply also, it is not fatal, because until his account,
I think this
because
submission is
anyhow it will be rejected, my Lord.
the submission is something contrary to your own circular.
Yes. No. It's a circular.
How can you say that?
Circular.
That I shouldn't reply?
No, my circular says if prior to the account turning NPA, my Lord. Prior to, it is already NPA.
Then what is Pronit's case?
Pronit's case, well, it clearly says, Pronit's case also, if your Lordship looks into it, there are three
Is
ways.
it your case that, as per Pronit's case, he has not come before you with an affidavit and verifiable documents you didn't consider? Is it your case?
That's not my case. My case is an NPA account.
My Lord,
No,
it cannot be.
13(2) stage will come only after NPA.
Please, my Lord.
Yes.
That's what is considered by Pronit's case.
Yes.
And they said that's for the borrower to say that I'm an MSME, and he has to come with an verifiable document with an affidavit and other things. That's what it states.
Swami Samarth has given a different, has given one more leverage, saying that even after 13(2), even if the account is NPA, they can, that's the last opportunity. If they give a reply, it has to be considered, is what Swami Samarth's judgment says. That's one extra, which is against the modification, as your Lordship has said.
What is court trying to look at it is, you have your own circulars, just follow it.
No, my Lord.
And you can't blow hot and cold at the same
No,
time.
your Lordship
One
may say-
time you rely on when some submissions have to be made, you say, this is a RBI circular, I can't go, I know I have to strictly follow it. Sometimes RBI circular is nowhere, this judgment says so. Every judgment has to say something, in line with the circulars. Or else we'll say the circular is bad, has to be set aside.
My Lord, if Lordship, even if we constitute a committee, my Lord, let us take it as the
We
committee.
will not assume certain things.
Let us
Have to.
So even then, my Lord, what is going to happen, my Lord? It's an NPA account.
In that case, why your circular? Tell your Reserve Bank to withdraw the circular. Nothing is going to happen. In case even if you
No,
constitute.
it is, my Lord, the Swami Samarth, they clearly say it is a confusing notification which has to
Then
be,
the Supreme Court,
and
then
they have
the-
interpreted
in the
that
Swami Samarth case, the
confusion.
Honorable
Yes.
Apex Court should have set aside that circular saying that it is something
confusing.
bad, but it's not done.
That is
So
not
as
done.
long it is there, we have to follow. So let us not create all this confusion. Let banks follow their own circulars and basing on the circulars, make submissions. If you are correct, we'll consider it. Yes, Mr.
Please, my lord.
Witness.
My lord,
So now my question is, 10/8/2023, they have said so.
said so, it's a request from their end at my lord page number 170. I'll just read it once again further. Your letter dated 4th August asked us to pay the OD amount of rupees 67.64 lakhs, upon which our account would be regularized and repayment schedule would be rectified, resulting in a monthly EMI about 25 lakh for about 12 months from the current account. That we wish to submit that we are working on the same and we need minimum 4 months for us to mobile and clear the OD amount and regularize the loan account, or making efforts to clearing the entire loan and close the account with you. Hence, we are seeking 31st December 2023. My lord, in fact, my lord, they admitted here also, my lord, there is a default. They sought some time, which you are not given. In view of earlier, my lord, various opportunity and restructure and COVID, my lord, again, my lord, in
But
respect
here
of
you make a statement on what is whether it is at this stage as per the circular to constitute a committee or not. That is what I want to know.
my lord, I may
Only
my-
simple answer. Don't make any other submissions. Basing on this, as per the Reserve Bank circular, is it a stage to constitute a committee or not?
My lord, I
Or
may,
you
I
can
may,
do
I
whatever
may,
you
I may
want to
permit you to
do.
make this submission, my lord. They are not said, my lord, I am an entitled benefit under MSME. You place the matter before the committee. That request is not forthcoming in the letter dated
So,
10th
according to
August
you,
2023.
unless and until there is a statement saying that please refer to the committee, mere
Their
when
request
explaining to you what is the difficulty will not entitle them to refer the matter to the committee.
They request in this letter for a restructure and they are undertook to pay certain money. We have given a reply saying that option or that, my lord, opportunity already afforded to you, we can't give it once again. Therefore, my lord, this reply we considered according to the law. Now, my lord, I'll go. No, not only this. Apart from this, my lord, I leave it to my lord wisdom. There are conduct I have, my lord. In my lord, I pointed out less than 250 crores.
What we
All
look
the
at-
cases are MSME.
Understand. We look at his conduct also. First we are on law, then we go to the facts also. So as far as law is concerned, make your submissions clear, then we'll go to that aspect.
My lord, according to me,
So
my lord,
let's
I will
not
not.
mix both.
We considered this representation as per his request. Since we have already afforded an opportunity earlier, we have restructured the loan. Hence, we rejected rightly.
And it's your submission that it need not be referred to the committee as per the.
In respect of this letter,
In respect of.
letter dated 10th
And
August
and it's
2023.
your submission that if it has to be referred to the committee, you should say in so many words that please place this
Then
matter before
that
the
is the
committee.
case.
Unless and until that kind of a sentence you find in the reply, you cannot keep it, you cannot place it before the committee. Shall I have to record like that? No, the submission,
I mean
make
to
it
say-
very clear.
No, my lord, kindly see, there are two letters before this honorable court. One letter, my lord, 10/8/2023. The other letter which I pointed out, my lord, which I said I am disputed. That letter, my lord, in conscience with my lord, they requested to refer the matter to MSME or committee. This letter also would have been same style, wherein, my lord, this letter they requested for a restructure, which we said, my lord, we are not able to do it since we already did it. Therefore, my lord, I need
So
not
if
refer
it
the
is
matter
your
to
case
committee.
that this is a concorded document, whatever they're referring to 10/25/8/20.
Please.
Then why did you not initiate proceedings against him, criminal proceedings?
Let them initiate.
I'll point out that. I wanted to come to that document, my lord. Why, my lord? I'll point out that. I give you, my lord, kindly effort, my lord, 5 more minutes. I'll point out that. Then, my lord,
No, we will not come back to this issue. This is
please,
clear.
that is my,
clear.
my lord, my.
Yes. So if at all that 25/8/2022 letter is received by you, 10/8/2022, his reply. Forget about 25/8, even 10/8/2022 reply is received by you. According to you, there is no sentence in that saying that refer it to the committee. You have not referred.
They request,
Yes.
whatever they request, we considered and we have rejected their proposal. Now, my lord, in respect of, my lord, the letter date 25/8/2023, I categorically, my lord, disputed the document in my statement of opposition by way of.
After that, you should do something else also. Not
My lord, they are not allowed me to do so. They've gone for NCLT. That, my lord, I will point out. They are accepted their default.
has come to your knowledge about this letter dated 25/8/2022 now after the writ petition is filed, not earlier. So once you say there's some document, according to when you are saying that you are not accepting that you have received and it's a concorded document. Something, we should have at least filed an application
Now-
before the court saying that initiate perjury proceedings against the
Yes.
petitioner. Where is that affidavit?
My lord, in fact, my statement, my lord, matter sub judice before this honorable court. I pointed before this honorable court saying that the document is not received. I filed an affidavit before this honorable court. That is not my seal. In fact, I pointed out the argument also. That seal, my lord, subsequently they produced it, my lord. In fact, I stated in my
Simple, Mr. Vignesh.
I would have, I understand, my lord.
Saying that,
In the
he's saying
institution like a
something,
bank,
denying
in the
it is not
institution,
sufficient.
in the institution like a bank, my lord.
You should say that please initiate perjury proceedings against the petitioner who has placed such a document before the court. Then we will deal with
Consciously,
it.
we are not done. In fact, my lord, I advised my client because managers are transferring one to one. My lord, that's for some difficulty which we have also, my lord, to file such application before this honorable court. My lord, kindly, my lord, it's a matter of fact. My lord, I'll just point out, my lord, two more documents. I'll leave it to wisdom of this honorable court.
So now this issue with regard to the document is also over. 25/8/2022 document that you have not come up with any, just simply making
simply.
just a
No
bare
response.
denial. No other steps are initiated by the bank. Either at least no application for perjury is filed before the court.
Please, my lord,
So you are
I
not
brought up.
seriously
Referring to page
disputing it.
77.
Yes, next. Next about the conduct of the petition which you want to point out.
Then,
Yes.
my lord, the petitioner approached this honorable court. My lord, kindly come to the writ petition which, my lord, I filed, my lord, in statement of page number 119. 19, next to R10. My lord, kindly come to bottom of the, my lord, page number 119, order dated 12/1/2024.
1 minute.
119, annexure R10.
119.
Respect of the other writ petition.
Other writ petition. In fact, I thought of, my lord, I
Yes,
pointed
yes.
before. Learned, my lord, page number 120, I'm reading. Learned counsel for the petitioner submits that because of the delay close to 12 hours, the account slipped into become NPA and the due has spiraled since then. It's admission. Up to August 2023, it was the indication of the bank that that amount due is rupees 67 lakh.
What we do is, before going into this, we'll look at what has been stated in the earlier writ petition.
Please, my lord.
This is
Yes.
Your writ petition, sir.
Please, my lords.
what is that 188?
The
I'll just,
one argument I would like to make is, my lord, in my writ petition, he does not seek for no representation,
Let's see what is this case.
no representation for MSME.
This case consistent with what is
para
been
9,
stated
my lords.
today.
Para 9 of the writ petition and the prayer.
And not all the,
I'll point it out. Para 9, my lords.
Yes. Yes.
Even though some business require more help than others, the debt recast, if allowed, has to be for all the officials cited above the condition anonymity. Adding any debt recast has come to some conditions. This incentivized restructuring rather than recognizing bad loans. During the course of so and so, RBI looked at the status of large corporate accounts across banks, which revealed significant divergence between reported levels of impairment and actual positions. This led the banks to recognize stressed accounts as NPA, resulting in a surge in the bad loan of so and so in the month of so and so. RBI has also asked the banks to provide 15% of the loan value of the restructured account to cover the risk of default versus 5% earlier. In 2019, RBI again allowed the banks and non-banking financial companies a one-time restructuring of the loans up to 25 crores of micro, small and medium enterprises that were in default and so and so without having to mark them as NPAs. Lenders are given an extension of up to 15 months to classify these stressed loans as standard. If this benefit was extended, my lords, I would not have been treated.
No, have you?
Prayer.
What did what did
all
you
the
say?
representation.
Prayer, my lords. Clause 2 and clause 2 of the prayer.
all against asking for the COVID benefit, which has been
Oh,
restructured.
2020.
No,
We
he
are
he refers to 10th August 2023
stress.
also.
My lords.
My lord.
He refers to 10th August 2023 also.
Yes.
My lord. That's the reason. All that there is no MSME. All these
No,
representation.
10th August is about MSME.
He's MSME only.
No, no. 10th August.
Again,
10th August is not MSME. my lord.
let's read that, please.
No, it is page number 82 in my writ petition.
Lords, I really fail to understand, my lords, because they have themselves.
Page number 82, my writ petition. The lordship may look into that annexure.
Agriculture majors and MNCs.
There is no MSME. There is no MSME.
Para number 1.
Para 1, we are an MSC, SME.
SME.
Yes, SME.
MN.
How to make a difference?
SME.
Small and medium enterprise, that's essentially what it means, SME.
Agri supply chain expert, having been an executive for 28 years, working in agricultural business majors and MNCs.
We are food and beverage industry and
They claim, my lord, they claim what they are.
The loan is
we are
sanctioned as an
so and so.
MSME.
But give me the benefit of MSME. Where do they say so? They don't say
They are
so.
not saying so.
My lord, the writ petition does not seek so. My lord, this amounts to estoppel, waiver, acquiescence, because here they don't take the stand of MSME benefit. Subsequently, they can't take. They have lost that opportunity. That is the contention I have been arguing. They have stopped from raising this plea.
Then this 25/8/2022 elaborates that, which is denied by you.
That
We have the original law.
my lord, if even assuming it is elaborated,
We have
what
the
I would
original.
say is, my lord, in this writ petition, when I issue my first notice, that was the first opportunity for them to
That is
come.
you have withdrawn now.
Come, but they had to say it's an MSME.
In continuation of that, only this
But
25.
my lord, they are stopped. My contention, my argument is their right to take that benefit. Subsequently, they can't.
Having received 25/8/2022, again you have issued a notice under 13(2) on 22/8/2023. What is the reply to this 22/8/2023?
20 to 8 minutes. I'll just point out. That is 20 to 8 is 25/8. 20 to
Yes.
8 again.
My lord, what I would say is,
For the
subsequent.
demand notice of 20 to 8 is the reply of 25/8.
Something which is inconsequential.
They did
I-
not
You have to look
no,
at it.
that is a different thing, my lord.
No,
What-
there is
what-
something.
My lord,
let
what the
them not-
notification says is prior to the account turning NPA, citations clearly say they have to come with verifiable. They kept quiet.
Lords, can I just pursue your orders? May kindly have a look at page 81.
You are not an individual. Bank is bound by procedure. Whoever is the borrower, you are not concerned. You are only stick to your procedure. That is what the court is trying to say. Nothing else.
What they have.
Court is neither in favor of the
I
borrower
know, we
nor in
absolutely-
favor of the
That
bank.
will not be-
We
will
want
be
the
complete.
procedure to be in place so that we don't have to interpret everything every day. That is what I'm trying to tell you.
I understand, my lord. Your lordship wants to, but very clearly, my lord, my plea is that since he did not take the plea of MSME in my writ petition, he has the right to choose.
Your right,
He's a stop.
writ petition is no more like it is instructions.
But he loses
For the
his.
reason, he says how many times you want, you can issue 13(2). However many ever times you issue 13(2), they have a right under 13(3). So that is already exercised by 25/8/2023.
25/8 minute which disputed
According
document.
to.
Now you
My
are
lord,
on the, now when
My lord,
it comes-
I'm on the my lord order passed by this honorable court, page number
that
190.
also, no. He speaks about any MSME in his writ petition, that we will say.
The writ petition, your writ petition.
No,
In my writ petition, it is there.
His writ petition.
Your writ.
ಇದೆ, ಅದ್ರಲ್ಲಿ ಇದೆ. That I think my para 9 he has mentioned. He has just said.
Para 9, we have said that
He
we
has
are
said that.
entitled for,
He
we
has
are an
said that.
MSME, we are entitled for restructuring. Para 9 of the writ petition.
The para 9, my lord, last end of the para 9.
Before treating it as NPA, you will have to give us the restructuring. We have said it.
Yes, now what is
Yes,
that
sir.
you are pointing out, Mr. Vignesh?
Please, my lord. Then, my lord, this honorable court pass an order at
One
page
more,
number.
what is the page number?
Page number 120. It starts from page number 119. I'm reading my lord 120. Learned counsel for the petition submit that because of the delay close to 12 hours, the account slipped into become NPA and the due has expired since then. Up to August 2008, it was the indication of the bank that the amount due is rupees 67 lakhs. Therefore, the learned counsel for the petition undertakes to deposit 67 lakhs. It's undertake, my lord, kindly, my lord, the 67 lakhs to the bank within 4 weeks from today, failing which the bank is at liberty to take action in accordance with the law. This is a firm undertaking given by the petitioner before this honorable court. Pursuant to that, my lord, this honorable court passed an order on, my lord, 12/1/2024. It is not in dispute. Now, my lord, kindly come to, my lord, page number 119, order dated 12/2/2024. The court on 12/1/2024 had passed the following order. Then counsel for the petition submit that because of the delay of 12 hours, the account slipped into become NPA.
Where are you reading?
My lord, I am reading page number 119, first order dated 12/2/2024. The court on 12/1/2024 had passed the following order. Learned counsel the petition submit that because of delay of close to 12 hours, the account slipped into become NPA and due has spiraled since then. up to August 2023, it was indication of the bank that the amount due is rupees 67 lakh. Therefore, the learned counsel for the petition undertakes to deposit 67 lakhs to the bank within 4 weeks from today. Failing which the bank is liberty to take the action in accordance with the law. Least the matter on good. Learned counsel for the respondent bank submits that not even a rupee has been paid by the petitioner pursuant to the said order. Therefore, the interim order granted 12/1/2024 stands vacated, reserving liberty to petitioner to seek its restoration once the order is complied with. Thereafter, my lord, this honorable court, my lord, for his, my lord, his,
Oh, right from 2023, what was the amount paid by the petitioner?
my lord, outstanding was more than 20 crore. If I would have been regularization to overdue some 63 lakh, as per his case, 63 lakh, 63 lakh. In the year of my lord 2020, his undertaking before this honorable court, which I am pointing out.
That is what I'm asking, right? From
63 lakh.
2023, what did he pay?
He's
to
not
the
paid
bank?
anything pursuant to
No,
order.
2023,
Except this 50 lakhs, which is paid by the
Nothing
order.
paid, nothing paid.
So
it's
this
not
order.
correct.
This order 50 lakh he paid pursuant to the order made by this honorable. It's correct. I'll make.
So what is the amount as of now to restructure the amount? To restructure
That,
the
my lord, I
account?
have to take an instruction, my lord, but lot of water flown under the bridge. The reason is this: they are gone before the NCLT. They admitted their default. They filed their, my lord. I'll point out from the records their own pleadings before the NCLT. They said that we are default. We are not in the position to pay. Their, my lord, sought, my lord, 99.
It's a 94 petition.
94 petition. There is an interim moratorium against me for a period of 3 years. Then we appeared. We filed a petition, objection stating that, my lord, only to circumvent my SARFAESI proceedings, they filed this petition. Then after taking on record, my lord, the honorable NCLT dismissed it. Then, my lord, period of, my lord, there, my lord, if my senior is
Right.
arguing in
No,
respect, no, I'll just point out.
RP is appointed, the 94 petition is admitted and RP is appointed. That statement
Sir,
may not be correct. I'm just correcting you. I can
Allah,
produce
in
it.
fact, I produced a document. You are not said anything, sir. My lord, kindly come to, my lord, the documents which I produced at my statement of objection. At, my lord, page number 121. They have not said anything before this honorable court in the writ petition. That shows, my lord, page number 121, annexure R11. The petition filed by the petitioner before the NCLT at Hyderabad, my lord, page number 131, tabular number 14. The petition filed under section 94. Copy of the demand notice so and so enclosed herewith, and also also, my lord, they stated that there is a default.
I'm looking at your objections.
In my statement of objection, page number 121.
120.
1. The application filed by the, my lord, petitioner before the NCLT. They admitted their default. 94, my lord, will be filed only, my lord. They will be not in the position to, my lord, pay, and they're accepting the default. They're seeking for IBC, insolvency against them. Thereafter, my lord, IRP has been appointed. Then I appeared before the IBC proceedings and I pointed out before the NCLT saying that only to circumvent my SARFAESI proceedings, this application has been filed. Then after hearing my submission, my lord, the NCLT rightly rejected that application. Therefore, my lord, I proceeded further. I issued 13(4) and sale notice, and my lord, I took the position of the property. Now, my lord, my respectful submission in this matter is, my lord, everybody, my lord, 250 crore means, my lord, more than 20% of the banking lending is, my lord, MSME. After doing so much, after their own admission before the honorable court, I undertake to pay 63 lakh. They gone before the NCLT saying that, my lord, I am a defaulter, I can't pay, initiate IBC against me. And, my lord, the intent of the, my lord, the guidelines or, my lord, the notification of the RBI in respect of, my lord, MSME, to, my lord, survive the company. When, my lord, they themselves say that initiate the IBC against me, my lord, what is the, my lord, consequence of the notification? In addition to that,
When you went to the NCLT?
my lord, the IBC, my lord, I'll just 121, the order passed by the IBC 155.
We will understand from the day when the moratorium is in effect.
Moratorium got
Probably that
affected.
around that time
Filed
must
by the
have gone.
NCLT petition. It's stated in my statement of objection also, my lord. One second, sir. Please, my lord, I stated my paragraph number, my lord, 5. Page number 5 of my statement of objection. I stated in detail. The petitioner suppressed the material facts before this honorable court. The petitioner earlier filed writ petition number so and so before the honorable court challenging the classification of NPA. During the hearing, the said petition on 5/1/2000, the petitioner undertook before this honorable court to regularize the loan account, paying the outstanding dues pursuant to the said undertaking. This honorable court passed an order dated 12/1/2024, recording the submission of the petitions granting time to deposit so and so. The order dated so and so produced. However, it is admitted that the petition failed to pay even a single rupee pursuant to the said undertaking, consequently by order dated so and so. The honorable court vacated the interim protection granted earlier and granted liberty to respond bank proceed in accordance with the law. A litigant who obtains interim protection giving an undertaking and subsequently violates the same cannot seek equitable relief under Article 226. Immediately after interim protection granted by this honorable court came to vacate, the managing director of the petition company filed an application before the filed under 94 of the IBC before the Honorable National Criminal Law Tribunal Hyderabad bench. The very invocation proceedings under Section 94 of the court necessary pursues the existence of debt, occurrence of default, and the debtor's inability to repay the same, and the application under Section 94 of the Insolvency and Bankruptcy Code 2016 notice here is so and so. By initiating such insolvency proceeding, the petitioners unequally admitted the existence of the debt and default. The respondent bank contested the said proceedings, and upon consideration of the submission, the Honorable NCLT dismissed the petition as dated so and so, order passed by the Honorable NCLT is produced here the next article. In view of the above petitioner having admitted default, in fact, my lord, default and my lord, they are not in the position to, my lord, either revive the company or, my lord, pay the money, just admit before the NCLT. Therefore, why the NCLT has dismissed? We filed an objection stating that this application has not been delivered. I have to sell the property under SARFAESI Act. Only to circumvent, my lord, my SARFAESI proceedings, they filed this for IBC. It's permissible under IBC. Pursuant to that, my lord, that application got rejected. Now, my lord, they're coming before this honorable court after taking the position of the property and put the property for auction, saying that, my lord, all the contentions before this honorable court will not serve for consideration. Either, my lord, the day one, they would have, my lord, pressed the application or whatever, my lord, restructured proposal, or they would have entitled for, my lord, in respect of guidelines, they would have come before this honorable court. They would have said, my lord, I am entitled under MSME guidelines pursuant to, my lord, RBI guidelines. It's not done so. Therefore, in this stage, after, my lord, lot of water flowed under the bridge, my lord, I 13-2, 13-4, I put the property for auction, I took the position of the property, my lord, more than 15 crore is outstanding. Now he's coming before this honorable court saying that, my lord, taking all the contention. Therefore, my lord, apart from that, the grounds or, my lord, the prayer which sought before this honorable court, one is classification and prayer. In fact, my lord, we argued many occasions before this honorable court. The honorable effects court said in the case of Virupaksha, classification of NP also to be assailed before the DRT under Section 17. In respect of sale notice, again 17. In respect of other reliefs, all are, my lord, assailable before DRT. In fact, these contentions also. Therefore, my lord, this rate will not serve for a consideration.
Yes.
Please, my lords. It appears that the bank does not intend to accept what they have done by themselves. To make a statement that we never went before the bank earlier to the NPA saying that we are entitled for the moratorium or this restructuring in terms of RBI circulars is absolutely a false statement. Because the documents which we have produced is not denied. Lords, may kindly have a look at the restructuring which was requested at page number 80. We have been requesting this commencing from page number 77. Commencing from page number 77.
Yes.
Let's page number 77, paragraph number 5.
Yes.
We said that you are not extending this moratorium of 18 months instead of 24 months as per the RBI guidelines. 6 months is only extended. Consequently, with the accumulated interest to the moratorium period, the EMI for all the loans will be so and so, which is totally impossible for us to meet. Then, Lords, may kindly see page 78. This is on 30th January 2023. Lords, what I refer to is 2nd July 22, 30th January 23. But I was paying, Lords, up to the month of April 2023, I have paid the EMIs. Then, here also again I said paragraph number 5 and paragraph number 6. Lords, then paragraph page number 79, 17th May 2023.
Yes.
Lords, we said at the third unnumbered paragraph, we request you to restructure the account, give us time for 6 months in opposition to EMI. Then we request you to restructure our loan so as to operate and improve the business. Again, my lords, on page number 80, 3rd June 2023. This is again before. We said we are again requesting you to restructure by extending the loan tenure to so the business can operate, which is with reference to the earlier. Lords, what they did is at page number 81, annexure M. They amortized this account. They agreed. Lords, it is under. It's only in respect of this MSMEs, Lord, that this restructuring is permissible. They in fact accepted and then amortized the account. But what they did, Lords, I just pause here and there, bring it to your Lordship's notice. They said that whatever will be the outstanding will be spread over the entire loan tenure. Notice my loan tenure is up to 2027, one loan account, the other one is up to 2030. But when they gave the proposal for the amortized interest, what they did was they actually shrunk it only for 6 months and gave it, commencing from 25/4/2023.
Like the order passed by this board.
Notice that 67 lakhs. Not so far as that 67 lakhs is concerned, as on that date, the bank said that we are due by 67 lakhs for the as on the date when the NPA was treated in the notice. But subsequently, what they have themselves realized is that as on the date when the notice was issued on 1/7/2023, I was not due. My account had not turned into NPA. As on that date, we should have brought it to the notice of this honorable court. We did not do, but as on that date, 1/7/23, my account was not an NPA. Lords, may now kindly come to the next document at page number.
What happened to your business from 23 to 26?
Business.
So even if that is restructured and they've given you some time, what somewhere by way of this IBC proceedings and all, you got the.
IBC, I will answer it. IBC is not by the company.
No, you got the time now. From there to now, 3
years. Now that's the reason why I said, if they had extended this benefit of payment, because up to March 2023, that is up to April 2023, we paid the EMIs. Thereafterwards, all these problems started, that they were not giving us the restructuring, nothing was happening. Now the working capital, whatever was infused, was already driven out. Then my business started shrinking to some extent. There was a financial stress. This is essentially what we have stated, in our reply dated 25/8/2023, saying that the financial stress is caused because of these problems. If only you had extended this benefit, we would have cleared everything. Because it is not that, I am a first defaulter. Pardon,
benefit of?
Benefit of the restructuring, if they had given, there was a moratorium of 15 months as per the RBI circular. The 2021 circular said you can give up to 24 months. If this moratorium was extended, the interest, moratorium only means that interest will be computed and added on to the EMIs, which will be payable after 24 months. It is not that the bank will lose anything. Bank will get the interest, but it will take it on a deferred date. That's essentially what the moratorium means.
They don't give for years, isn't it? They
then,
will not give for years.
Yes.
Together.
Now what happened?
They'll give you even as per that, you're entitled for 15 months, 24 months.
Now I'll say
so all that period is also over.
No. That's what happened was, when they amortized my account and said, this is the difficulty which I faced, that up to the end of the tenure, I will give you the interest benefits. They shrunk it for 6 months. The EMI which I was paying at 5 lakhs, they made it 33 lakhs. In 5 lakhs, I am unable to pay this because of the stress whichever was caused. This is a brewery industry, virtually shut down during the COVID. Not even a single rupee was generated. 5 lakhs is the EMI which I was paying. I produced the statement of accounts. 5 lakhs is in respect of all the accounts. 5 lakhs is the EMI which was being paid. Because of this amortization and being extended for the remainder of the loan period, they shrunk it to 6 months and said that you have to pay 33 lakhs. If not for this 33 lakh rupees, which I actually paid for 3 months, January, February and March, I paid it. If not for these 3 months, that 5 lakhs to 33 lakhs, probably I would have been still in a position to pay this money. They will not be in a position to dispute that they shrunk this to 6 months and made 5 lakhs to 33 lakhs as my EMI.
Your proceedings before the NCLT and your
request I have
for,
not gone.
No, your request for
I have not gone. The company has never gone.
Who has gone then?
No, it's one of the guarantors.
Managing director. Managing director and the 2 guarantors. Managing director of the
he cannot say it's a managing director. The person who's gone as an individual. Section 94 is by an individual.
Where is that?
That's page number 121 along with the statement of objections is what they refer to. Kiran Shankar Reddy Mudda. Company has never, he's a
family.
He's a guarantor.
It's a family.
So far as Kiran Shankar Reddy Mudda is concerned, he as a guarantor for this loan went before the NCLT. Milords, at the most, what would have happened, Milords? I'm just saying this. The loan in respect of this company would still survive. It's only.
Who has gone before the NCLT?
No, it's this Kiran Shankar Reddy Mudda, who was one of the directors of this company and whose personal property is given us as a guarantee to this.
Present property which is sealed before this honorable court.
Reddy is none other than the
property owner which is sealed before this honorable court.
Milords, a company has a distinct entity. The company is also having its assets. I wanted to say this, Milords, the company is also having its assets. It is not that the company is not having its assets. The brewery and the industry where it is running is a property belonging to the company. Not that the company is not having any assets. Milords, it is not that the. Now, next, what happened, Milords, is after they amortized this, Lordships may kindly see, Milords, they issued the second notice. 1.7 is a little important, Milords. If your Lordships were to kindly have a look at that 1.7 notice. I'm sorry, yes, 1.7 notice. That is,
1/7/20.
2023.
Demand notice.
Is a demand notice. That's 10 crore 16 lakhs is what they say is due, and then page number 114. However, from 31/3/2023, the operation and conduct of the financial assistance credit facilities have become irregular. Books of accounts maintained by the secured creditor shows liability towards so and so. And therefore, from that date, Milords, 90 days. So now this NPA is treated. Subsequently, they say that therefore we have treated this account as an NPA. Before 1/7/2023 itself, they had already extended the amortized interest on 25/4/2023, saying that we are entitled for amortization, but they did not extend, except for this communication. Had they actually given effect to this, my EMI would have increased by around another 45 to 50,000 rupees. But that was up to 2030. The interest period will not for 24 months. They will postpone it. Since they again shrunk it to 6 months, which I was payable required to pay within 6 months, it increased from 5 lakhs to 33 lakhs per month. This is my problem. Then after this notice, Milords, I gave this reply. Nothing different from what I had stated earlier or what I had stated in my writ petition, by which time I had already come before this honorable court. On 22/8/23, I filed the writ petition, challenging the earlier notice because as on that date I had not received, Milords, this. Now, Lordships may kindly see what this 25/8 reply. It's 22/8/23, Lordships may kindly take at page 119. Which is their demand notice. And the reply is on at page 127. We have produced it along with that. I will also take your Lordships, what is that they don't want to extend. We wish to submit that following to response yours so-and-so dated 22nd August 23. We are an SME in food and beverage industry founded by professional group. Having said that, in the last 3 paragraphs, we say that we submit that bank did not apply RBI norms in, sorry, Milords, page number 127.
Yes.
Paragraph number 8, para 1 and para 8.
Yes.
We submit that the bank did not apply RBI norms in restructuring an account, namely, we give a detailed description of whatever happened. Then clause 4 in page number 128.
Yes.
Consequently, can I just read that, there is some importance to this in the light of whatever I have submitted.
Yes.
The guidelines with annexure 0.9 clearly states resolutions planned may inter alia include rescheduling payments, conversion of interest accrued to be accrued into other credit facility, granting moratorium based on assessment of income streams of the borrower subject to maximum of 2 years. Correspondingly, overall tenor of the loan may also get modified commensurately. The moratorium period, if granted, shall come into force immediately upon implementation. As can be seen, our loans have not been extended or extended only by an year, thereby resulting in an EMI of rupees 32 lakhs rescheduled payment. Further, the bank has not considered income stream of the business in fixing the monthly EMI of 32 lakhs. Consequently, AMI of payable post moratorium has shot up to 32 lakhs per month, causing extreme financial stress to the business, leading inevitably the company not being able to pay the EMI promptly. Company has since the day it received the revised EMI schedule post restructuring, has brought to the notice of the bank officials both orally and in writing rectifying the EMI amount by extending the tenure. However, our multiple request representations elicited no response from the bank. We request you to take note that you have not extended the tenure as per the RBI guidelines, resulted in the EMI of rupees 32 lakhs from rupees 10 per month pre-COVID, resulting in company inevitably so on. So further, the delay in restructuring your account to extend the tenure since April 23 has also inevitably made us unable to continue to pay the huge EMI of 32 lakhs. In our effort to continue to keep our account standard as also demonstration of our intention to repay the bank, we have with extreme difficulty paid January, February and March. Thus, a total of 97.42 lakhs was paid by us over the 3 months. Business turnover during these 3 months and the EMI paid are detailed following table. We have given this minutes. What is our turnover, etc.
Now the fact remains is, right from 22/8/2023, you have not paid anything till 2026, till this 50 lakhs as ordered by the court.
No, we have not paid.
So you want restructure of the loan or referring to the committee, everything is for the fact. You will be getting some reasonable time, or let's say 6 months,
yes,
1 year, so that you will not be paying the interest, but however you will be paying the
bank. The restructuring does not mean that I will not pay the interest.
No, you will not pay they will give you some
Immediately,
time.
Milords, what?
Immediately.
Yes, immediately I will not pay. Milords, it will be a deferred payment of interest.
That's it.
That's all what is provided for.
What is happening from the last 3 years? Now you had some deemed kind of, the what you wanted from restructuring, you have already got it from the last 3 years.
Milords, I'll just say this, Milords. If my EMI was kept as per the old rates, by extending this amortized interest for the remainder of the tenure as admitted by them, if this 33 lakhs is taken into account, I would have paid at least by around 12 months. I would not have paid for 3 months. I would have paid for 12 months because they said it is 33 lakhs.
Even if that way we take it, by this time you would have paid some amount or the other. Even for paying this 50 lakhs itself, you were like, the other day the instructing council was asking for time and all that.
We paid this 50 lakh time. What happens? Now I have no voter facility. The voting facility is now frozen. That is one of the components of this NPA. So they did not extend the OD facility on the premise that it was that one my term loans has turned out into an NPA because NPA the EMI is increased from 7 lakhs, 8 lakhs to 33 lakhs, 32 lakh rupees they increased it. So this was not possible for me. Then if the OD is not there, I don't have the working capital. Now, these are all the businesses which is like running with the fuel. If the fuel is not there, I cannot run the business because working capital, without working capital, till now I have not stopped the industry. The industry may be working with a very slim force. If I had shut down the industry, the capital value of the asset would have shrunk to 25-30%. I have kept the capital value intact. If only they had extended this benefit. Not even that. Now what we are asking is you extend the benefit you should have placed before the committee, because we have been consistently telling you that please extend this benefit so that we will continue to pay. You considered it in part and said, all right, we will extend it for the remaining 24-month reminder period. Even that they did not do in practice. Then ultimately this is what we have said. In our representation itself, we have stated, paragraph number 17, that we have approached this honorable court requesting that this benefit should be extended in our representation. Just 3 judgments is there, I will not trouble your lordships. I'm grateful for the hearing. That it's already filed,
It's already filed.
Your lordship's judgment, Pronit's case and Swami's case, it's my learned friend is referring to. All 3 is given.
On a lighter note, my lord, in Bangalore, that's the only business which is doing very, very well. At least past 3 months, 3 years, he could have easily paid off this loan because liquor business is the hot selling product in Bangalore.
Heard, reserved.
Grateful, my lords. Lords, can I request, that let them deliver back the possession 50
But
lakhs
that
of
belongs
it.
to the guarantor who has filed IBCA proceeding.
Very well, my lords, I leave it at that.
Cell number Vijay Kumar TM. Cell number 3 Vijay Kumar TM for petitioner.
The list has gone along with.
Give me the judgment. Rashmi Traders is not it.
3 Vijay Kumar TM.
Yes.
Sorry.
On maintainability 3.
Yes. Vijay Kumar TM.
What is this objection with regard to maintainability? May not be maintainable if a principal venture Bangalore as an impugn annexure is issued by Canara Bank Hubli. The office has raised objection with regard to maintainability of the writ petition. As a petitioner has questioned the preceding the notice issued by the Canara Bank Hubli, considering the fact that the bank is situated at Hubli and the properties are also within the jurisdiction of the bench at Dharwad. The writ petition before this court is not maintainable. Office objections are sustained. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the bench at Dharwad within a period of 45 days from the date of receipt of the copy of this order. Yes, next.
Cell number 4 hearing on ISG Rajshekar. Mithun GA.
Because I had one disability, my lords, because yesterday by the time I went back home, it was 9 o'clock. I had to go straight from here. Morning when we tried to get the printouts, my lords, I could not get the printouts because the computer is neither, the printers are neither working in my office because it's a Wi-Fi printer, nor I could get the prints. Even we tried it here, my lords, in the High Court, we could not get. But lords, only to say that Phoenix Arc did not consider Mardia Chemicals.
It is considered.
It's not, my lords. I just looked into it. Matthew Varghese is considered. Mardia Chemicals is not considered.
But
Mardia Chemicals is by 3 judges. I just pass it on, my lords. I just refer it to this, and I'll just request, my lords, your lords may treat it this as parted and then take it up immediately after vacation, because a very interesting question which your lordships, I have to answer this, my lords. I just refer to this.
I think again, there is no prayer in his first response. You do not have to say anything. It's only either it's 2 and 3.
Who is 2?
Tata Captain.
No, the reason why the other respondent is there is, once when that person offered the property for sale, we were not aware. We purchased the property by taking financial excess.
After vacation.
Yes, my lords.
After vacation, interim order earlier granted is extended.
Please, please.
The Senior Counsel submits that with regard to the maintainability of the writ against LNT Housing Finance Limited. Will submit documents after vacation. Yes.
Grateful.
Number 5. Cell number 5.
Petition is not maintained.
Appearing for petition in this case, my lords.
Yes. Take that.
My lords, after vacation, it may be listed, my lords. As yesterday, it was fully fledged, my lords, in office.
This is a authorized officer, S Bank Limited.
Yes, my lords.
As on date, outstanding is
Because it is not maintainable, they have moved a memo. List along with this writ petition, this WP earlier, we'll hear it after vacation. Along with this 4
Interim orders may be extended, my lords.
interim order, earlier granted is extended till then. Yes, then.
Grateful, lords.
Yes,
Cell number
next.
6.
My lords, we were directed to file one affidavit, my lords, of undertaking. The client is not in station, my lords. He said that once he's back, he'll give a proposal for NPA for one OTS, my lords, one-time settlement.
Let him
I
approach
request
it.
for some time, my lords. My lords, he has paid up to 55 lakhs.
Very clear. If the undertaking affidavit is not on record, the writ petition will
Please,
be
my lords.
dismissed.
The statement was produced 2 days back. According to that statement, they have admitted, my lords, that he has paid about 55 lakhs so far. The remaining is about 1.5 crore. Is
A crore and a half is not a small amount.
I understand, my lords. He's paid about 25% of his debt and they've closed 2 of his accounts. Three other accounts remain. He wants to.
I'll not grant any interim order. I'll post it after vacation. It's for you. Whatever you want to do, you do. This is matter after vacation. Yes, next
Number
7.
7. Cell number 7.
The petition.
Let it be.
The matter, my lord, the filing the undertaking affidavit.
Take that.
But I sought four months time to file entire the amount, and the position was that taken over.
Position will be delivered once you pay the amount.
Lord,
I appear for the respondent number 1 counsel.
Entire tenants are vacated. I can even helpful for my lord if it is delivered on payment of 50%.
No, yes.
My lord,
yes,
I appear for respondent number 1, my lord. Counsel is not well. Yeah, respondent number 1, bank, my lord.
Yes,
Counsel is not well.
That, he will pay the entire amount within 4 months. Basing on that affidavit, will dispose it off.
My lord, the NPA has been declared in 6/8/2019, my lord. Since 6/8/2019 till date, not even single amount has been paid. Thereafterwards, my lord, even before the DRT.
No, he is paying something. If he doesn't pay, I'll impose a condition that he has to pay what is outstanding.
19 lakhs as per the 14 section 14.
No, my lord. As of now, it is 32. My lord, as of now, 32 lakhs 39,871, my lord. 32 lakhs 39,871, my lord.
Did you mention the amount or whatever outstanding you mentioned? Entire amount. He said
entire amount.
Entire amount.
As per the order, annexure A is the 19.
There will be order from 12/11/2024. It would be the same amount after 2 years also.
They have taken possession also.
It is not interest. That amount will be the same from that day to till now. This is matter after vacation.
Lord, the interim protection, Lord,
they have not sent me a copy of the IA and
Lord, my property will be.
Where is the interim protection to you? Was it given earlier? No.
Earlier not.
No interim protection.
Dismissed for non-process.
No. Before that, I'm saying before dismissal. Were you enjoying any interim order? No.
No, my lord. No, my lord.
Yes, next.
It may be recalled.
Grateful, my lord. Grateful.
That day I'll hear it after vacation when you come up with the appropriate application. This is matter on 4th of June.
Grateful.
Number 8. Yes, Rajshekar.
This is yesterday's matter, my lords. I have advised them, my lords. And they are on principles, my lords. They have agreed to, my lords, to approach DRT. My lords, only one submission they have requested me to make, my lords. It appears, my lords, respondent number 2 has approached the bank with one-time settlement proposal.
Who the borrower?
Respondent number, borrower. Now, what my clients have instructed me is, my lords, if he wants to settle with the bank, my lords, they have had a discussion with, my lords, the borrower to pay whatever amount we have to pay, balance amount, and let them, my lords, negotiate with the bank for one-time settlement. And they will do it. That is what, my lords. So they have requested me to make this submission, my lords.
No. What is that? What is that? The court
now, my lords, these petitioners will have to pay some amount to the borrower. Balance sale
petition. Now the parties are now relegated to the DRT.
Yes, please.
If at all it is maintainable and if they have any grievance.
That is
fact. Now whatever submission you are making.
Now, my lords, they wanted to approach the bank and take it forward further. Immediately after vacation on the reopening day, my lords. So that is what I am requesting, my lords.
My lord, this matter was heard for several
no doubt.
hearings,
So
my lord.
what I'll do is
Now,
1 minute. I'll take up this matter on the reopening day as a part heard.
Yes, please.
That day I will only dismiss it, nothing else.
Yes.
So all the while, right from 25, they are enjoying the interim order.
Yes.
Let it continue for 1 month, doesn't matter.
Yes, ma'am.
This is matter
And
after
second.
vacation on 1st of June as part of
Interim order.
interim order earlier granted.
In case if they don't go ahead, my lords.
On that day, well, whatever happens. But
Yes,
I'm
my
going
lords.
to
Otherwise,
dismiss
I'll fairly submit, my lords. I'll go to
dismiss the
DRT.
petition, whatever it is.
Yes, please.
As not maintainable before this court.
Cell number 9 adjourned. Cell number 10.
appearing for the petitioner in this matter. This is a disposed of matter wherein 6 months time on 6th installment was given to me.
Something like bank wants some clarification in the order.
We wanted position we are given. I think you got.
Possession ಕೊಟ್ಟಿದ್ದಾರೆ.
No,
Possession,
they
in
want
fact,
the
my lord,
document,
possession
my
they have
lord.
given.
They have objections. Let him finish off the payments. They are ready to give.
See what it is. What is the order? Let me just look at it. Where is the file?
My lord, 6 installments, equal installments.
Let me just look at it.
Yes.
Please only give the order. Shall clear the balance amount, that is 8 crores within 6 installment. 25/4 by 25, and the petition shall clear the entire outstanding amount. While paying the last installment, whatever are the expenses are into the group shall be informed by respondent number 2 bank to the petition in addition to the last installment. Bank shall forthwith deliver the portion of the property that is
Yes,
there.
they have delivered. In
Then
fact,
what
my lord,
else you want?
no, in fact, what has happened is 25th, 25/4. Before that, my lord, I have deposited that 1 crore 44 lakhs being the first installment. Now, by virtue of that deposit, my lord, one loan gets totally closed. So it is now closed. And what I am requesting is one property which I have given as mortgage in respect of that particular loan. That property let them discharge, because there are another 2 properties which are nearly worth 20 crores. Their outstanding is now hardly 6.5 crores. Because since loan is cleared, my lord, let them discharge that property.
We'll find out, my lord. I filed my objection. The bank who says that procedurally we can't.
We'll have it. Let
after
him also
vacation.
get instructions. We'll
After
have it after vacation.
Yes.
My lord, if my lords could kindly, my lord, some more deposit also I can make subject to that, because holding my property, my lord, it is affecting me a lot. 3 properties they are holding.
No. But that issue will come when in case of one-time settlements and all.
No, here, my lord, there were totally 6 loans. This is a project specific loan, and this particular property is given exclusively for that loan, which is now cleared. That they have given, the bank themselves have given the letter stating that that loan is closed.
Have you seen that?
I'll serve the copy.
Just spoke to them, my lord. They did not say that we can hand over. Let it be after vacation. I will just consider, speak to them in case they have objections. They'll file objections. Otherwise, I will tell you something.
My lord, my difficulty is, may I make one submission?
This court by order dated 1st April 2026 has disposed of the petition directing the petitioner to clear the entire amount by 25/9/2026. That is an amount of 8 crore 51 lakh 22,747, and also directed the bank to forthwith deliver the portion of the property. Now the present IA is filed. IA is filed seeking a clarification oblique direction. It is submitted that altogether there are 6 loans. How many loans?
My lord, 6 loans, out of which, my lord, 3 are now closed.
6 loans, and out of which 3 are now closed. The bank has also given an announcement in that regard. It is submitted that in respect of the loan account, loan which is cleared, if the bank delivers a portion of the property, discharge the said property, still there are 2 properties which are worth more than 20 crores, and the petitioner and the outstanding amount is only 8 crores and odd, which is due to the bank as per the order passed by the court. Hence, there may be a direction to the bank to discharge the said property. Land counsel appearing for the bank submits that he has to get instructions. The list is matter after vacation. In the meantime, in the light of the fact that the petition has already, a particular loan account is cleared, whatever is a property that is mortgage for discharge of the same, the respondent shall consider the case of the petitioner. List is matter after vacation.
May I
If
request
it doesn't
for
do,
one submission? Your lordships are sitting in vacation bench for 1 day.
Huh?
During vacation bench, your lordships are sitting in this thing. If this matter is listed on that
Why
day.
should we compel him to come to the
No,
court?
the reason
for
is this. The reason is
So it
this.
doesn't matter, it's hardly a week. Little come on the
No,
first.
I'll make one submission. The reason why I'm requesting is, well, my next installment comes within next 25th of May, I have to pay another 1.5 crores.
No, what
by
I'm
the-
saying is, I will be taking up this matter on 1st of June. So it doesn't matter from 26 and what.
No,
26 is the
by
first
that time, I have to
vacation.
deposit the amount.
Mm.
Well, if this property is freed, well, I can make the arrangement easily and I can even clear off the entire loan. That is my endeavor. During vacation, your lordships
Take it
anyway,
on 26.
please.
Appear. No.
Well, my friend can even appear on VC also. We have that facility.
No, consider it because it's good for you and him, isn't it? We have to consider their, so we'll have it on 26, whatever, no, virtually appear on, or your colleague will appear, he'll submit. Why nobody is available to the, to internet facilities, you're going somewhere where internet facilities are not available.
Because,
On first,
please.
Cell number 11. Preliminary hearing 11, Ajay Kumar.
My lords, here, my lords, I'm challenging. I'm not party to the order passed by the AC under section 23 of the Senior Citizen Welfare Maintenance Act. Here, my lords, where I'm the agreement holder.
notice is also not served till now.
Notice is not served. What has happened is that I'm an agreement holder.
Notice is, huh?
I'll take notice for R1. madam.
R1.
R1.
R1 AGA takes notice for, look at it, how many respondents, so and so. Notice,
Yes, my lords.
issue notice. List this matter on 10th of June.
10th of June.
Cell number
12.
12.
If I may submit on the interim relief, my lords, because my suit for specific.
Can't have an interim relief in a 2023 writ petition, we'll see.
Yes, my lords. I'll come on 10th.
This also same,
Yesterday's matter, my lords.
we'll have it, this also.
Because I'm
after.
only saying that I'm in possession of the property, my lords. They have auctioned the property.
Without deciding that, because so many writ petitions I've dismissed, I can't take a different view. This
No,
is
no,
matter-
lords, my lords, lordships may recollect. This is a matter where your lordships relegated me to DRT. DRT said that section 14 was not applied. That's
Oh, I
matter.
was under the impression
No,
that
no, my
a
lords,
writ
this-
petition is filed before.
No, no, no.
You're questioning the order of the DRT.
Yes, my lords.
Where is that?
Lords, page number 78, para 19. Yesterday, my lords, I had given your lordships three
Yes,
dates.
Yes. Sir.
The writ petition was filed on,
Where is the order?
lords, page number 78, paragraph number 19, page 69, it starts. Page 78, 69 at page 78. None of the.
No, what he was, Mr. Xavier, what he was submitting yesterday when a senior counsel was, they've gone before the tribunal within the time as granted by this court. So, there's no question of delay at all.
On 2 counts, the tribunal has passed an order.
No. Ultimately, the SA is admittedly filed with a petition to condone the delay in filing the same. The issue so and so, that's the main issue. Other issues, we will ask them to decide them. We'll keep it open.
He has already decided.
No, these are all, now if you look at, these are all the passing remarks.
Passing observations like para 18, my lords, they say that I'll not go to
Ultimately, it is on the question of delay.
delay only.
According to them, they're on time. Have you looked at it? Because yesterday, what are the days you have been mentioned?
Lords, I just give the dates, my lords. 10/11/2025, the writ petition was disposed of. Lords, your lordships are granted 3 weeks time to approach the DRT. Lords, DRT's jurisdiction was invoked on 25/11/2025, within 15 days. I'll just pass on this order copy to you.
So,
Yeah.
so there is no question of delay. Problem is, the petitioner has complicated the issue by filing an IA
Yes, my lords.
to condone the delay.
Lords, what happens there, Mr. Francis is also aware. The moment we file a petition saying that this is the action which we are challenging, it will not be put up before the court till such time we file an application. So,
Even for orders of the.
no, it will not come up. So that has to be complied. So thereafterwards, matter comes up before the
Will
tribunal.
set aside this order.
Lord, even otherwise, the sale notice was issued on 11/5/2020.
He has immediately approached this court.
This court,
Was approached on, for instance, page number 50, 26/7/23.
26/7/2020.
My
Page
lordship,
50.
I appear for the second respondent. I'll take notice for the second respondent and copy has to be served on me.
Lord, the
Page
was around 10/7, my lord, the 10/7/2020 sale notice.
45 days time,
12/7.
isn't it? So that is also within the time. So what we'll do is, as far as this issue is
One
concerned,
submission, my lordship.
who is second respondent?
I'm
She is the
the,
second purchaser.
Who is
Purchaser.
second? Huh?
I'm the
Auction
purchaser,
purchaser.
auction purchaser.
Oh, auction purchaser.
Yes, I have been delivered with the sale certificate, my lordship.
No, we are not doing anything. We are only concerned with this order, which has failed to consider the case of the petitioner on the ground that there is limitation. It is within limitation. That's what we'll observe. We'll not do anything. All of you go before the tribunal again and
No, this honorable court was pleased to grant time liberty to go to DRT only on the basis of the petitioner arguing that the account was based on NPA is not proper.
if that is on that ground, the court
Grievances
passes
is
a.
that the delay has not been controlled by.
Huh?
That is the grievances. Lord, the petition has been filed. Lord, the DRT has given the liberty to go to the
No,
DRT.
generally,
That is
what
the-
happens, happens is, whenever we say 3 weeks, so we don't say that they have the benefit of section 14. That means that the court has given the benefit.
They have already filed the OA in 2022, my lordship.
So, all that, let you please agitate before the DRT.
No, on the same cause of action, they have approached the DRT again. That was
Dismiss
dismissed.
the ground on which the DRT has dismissed this. Let it consider it on the merits of it. You also argue that. Let there be an order.
It's already on the merit, my lordship.
No, it's not. If you look at it, some remarks are made finally. He's filed with the petition to condone the delay. That's the
That means
main.
they may serve the copy and my lordship, it may be listed after
Will
the
happen is,
vacation.
now again, this order is stayed and all. Unnecessarily, you will be losing the time. If you allow the court to pass the order, I'll remand it and ask them to, appear.
Within
Give a
3 months,
date-
it could be
give a
disposed
date
of.
for the parties to appear, and within a short time, I'll fix and ask them to
Permitted to read the paragraphs of the order.
paragraph.
Paragraph, page number, para 15, 16, 17 of the order. Final order of the DRT. Even though applicant is disputing the service of possession notice, the tribunal is not intended to go into the said issue for two reasons. One, that impugning measures, the applicant has already filed SA 208 of 2022 and failed to prosecute the matter, resulting in dismissal on 12/6/2023. And secondly, for the reason that the challenge against the possession notice is hopelessly barred by limitation, as this point of time, by virtue of the mandate under section 470, every action taken by the secretary is to be assailed within the 45 days. Section 13(2) and 13(4) has been challenged in the SMA law. That has been dismissed.
That is
What has
factually,
been challenged before the
Lord,
court
that's
is the-
factually incorrect. The
What has-
sale notice is dated 12/7/2023.
the next paragraph.
Which could not have been the subject matter of SA 208 of 22. There, what was challenged, my instruction is section 14. They wanted to take physical possession, which was challenged. Section 14 alone was challenged in SA number 208 of 2022. After the sale notice is issued on 12/7.
Then counsel appearing for then senior counsel appearing for the petition submits that the court has failed to consider the fact that the petitioner has approached the DRT within time and there is no delay. Delay on another aspect, on other findings of the court also, submissions are made considering the submission of the land counsel, there shall be stay of all further proceedings.
That will be an order of status quo on its side.
Let there be an order of status quo
Regulating.
till the next date of.
It's already 2.5 years I have paid the amount, my lordship.
This is
Sale
matter on
certificate has been issued
second.
2.5 years ago. It has not been
Second, I'll
fixed a
give
date,
it.
my lordship.
Please, please.
Cited on second.
Grateful.
So and so counsel submits that. Your name is not there, Mr. Zain.
It's not.
I am permitted to enter on behalf of G1. G1 is not the panel.
Oh, you are representing. For respondent number 2, it is submitted that so and so has
And served with the copy of the.
So and so has
I'll ensure, my lord,
instructions
the
to-
copy is delivered.
Instructions to file the wakalat. The land counsel, the petitions are the copy of the writ petition on the counsel appearing for the respondent number 2. You already received.
My lord,
Great.
name is
Your name in place, Mrs. Xavier, Francis Xavier, for Armor. delete the name of Mr. Jeevan Kumar. Yes, 13.
Serial number 13.
I think kindly recollect, my lord, in this matter. This court was refused to grant the interim order. My lord, they are challenging the order passed by the Honorable DRT.
Anyway, he's not here.
Anyway, my lord, maybe it is 1 crore 50 lakhs is the.
No interim order, no.
No, interim order was granted earlier.
On what ground?
There is an interim order in the first instance.
By the time the amount for both the first and second installment,
My lord, they say spending for the DRT, my lord, let them go to the DRT and.
then the order will be set aside or else the writ petition is dismissed. If the amount for both.
1 crore 50 lakhs is the EMI outstanding, my lord, in order to regularize.
There is no representation on behalf of the petitioner. The interim order granted on 23/4/2026 stands vacated. This is matter after vacation. On 10th of June. Is 14?
Serial number 14. Suhas G.
No, but we have received this thing saying that some of the advocates have not received the file. I mean, received the what do you call it, the list because of this internet issues. We don't know whether he has the same difficulty.
That's the reason, my lord, I am not pressing for dismissal.
So don't vacate it. There is no representation. This is matter.
My lord, even otherwise they have not completed the order. The court has directed.
The list is matter. Land counsel appearing to the respondent submits that the order passed by this court is not complied with. List is matter on 2nd of June.
Okay.
Yes. 14.
14.
May I please, my lordship? Appear for the petitioner. I am the auction purchaser, my lord.
What is the relief you are seeking before the court?
My lord, forfeiture notice, my lord. It is at annexure A, page number 7.
In 12. 12, it's already said. 13, delete the name of Vignesh Shetty in the name of Mr. Francis Xavier. Yes.
My lord, forfeiture notice, my lord, which is annexure A, page number 17.
When was the auction?
My lord, auction was on 17/2/2026, my lord.
17 to
2026, my lord. 18/2/2026, I deposited 25% of the bid amount, my lord. That is 30,50,000. Then, my lord, the bank has issued sale confirmation, my lord. That is on 19/2/2026. 19/2/2026, my lord. Then I addressed. When I visited the suit shared property, there was a board at the suit shared property stating that there are pending cases, my lord. Then I gave a representation on 28/2, my lord, seeking clarification with respect to pending litigation of the property, my lord, which bank has not given me any communication. Then again on 2/3, I gave another communication to the bank, my lord.
They didn't respond.
No, my lord. Then on 2/3, they said that there is no stay with respect to the suit shared properties, my lord. However, I received notice on 3/3, my lord.
Forfeiting the amount.
Please, my lord. Forfeiting the amount. Wherein, my lord, the borrower, my lord, he has filed another writ petition, my lord. In that writ petition, I was made a party, my lord. In that,
What is that writ petition? Is it
my lord, kindly come to annexure G at page 35. No?
Is it pending consideration?
No, my lord, it is disposed of, my lord. It is
Where is
disposed
the
of.
order?
My lord, it is at page number 35, my lord. In that writ petition, your lordships has confirmed that, has passed the order not to confirm the auction for a period of 4 weeks, my lord.
Deposit 20%. Is not inclined to consider this as, but however, coming to the merits of the matter, the petition is questioning the sale conducted of the bank, and they have an effective order before the date in that way of the matter is court passing the order.
Please, my lord. This order was passed on 17, my lord. 17/3.
This writ petition is filed in 2026 itself.
Please, my lord, 2026.
So,
This was
whether
on-
there is any encumbrance on this property or not.
I'm submitting. Everything is replied. They are suppressing. ಎಲ್ಲ ತಗೊಳ್ಳಿದ್ದಾರೆ ಮೇಲ್ is sent.
Take that.
Court officer, madam. Madam, my lordship, page 6, my lord. What their allegation is, a board is displayed on the property telling State Consumer Forum cases pending. Page 6, my lord. See, this borrower is a notorious and litigant, my lord. 15 writ petitions he filed.
Please read this. Then
And
counsel
the
of both
order is
sides-
on, my lord, and come to the order on.
My lord, I am not
16
concerned
to-
with the borrower, my lord. I am the only purchaser,
16
my lord. We have
16
no-
Where is your reply to his correspondence?
This is the reply, my lord. My lord, you see that page 5,
Page number 5. Yes.
Page number 5. I'm ready to pay, request, I mean, this one. Page 4, my lord.
What did you say?
See, he said the consumer, my lord, on 6/2 orders, they sought for injunction in consumer forum. That was vacated.
Asking, he has requested you on 8/20.
This is the reply, my lord. This is what I'm coming. I'm
28
coming.
to 2026, where is the reply? 2/3/26, where is the reply?
Right, kindly
My
come
lord,
to-
page 5. Page 5.
Yes.
28, February 28, 2026, from the branch. Please find attached documents and providing clarification regarding the cases currently in the consumer court related to the property. I have purchased. This is the reply we given. This is the PDF telling that stay is vacated. Post vacation of the stay, this property is sold. And with regard to High Court, no, your lordship was pleased not to issue notice. Unilaterally, he appeared, filed the wakalat. There was no stay. And then,
Now, as of now,
My lord,
there
I
is
am,
no, only issue is with regard to the consumer case. That is there, that is not there now.
no, my lord, the reason is that I'm ready to pay the,
The consumer case is concerned with the property.
my lord, there was a stay, my lord. There
No
was
stay,
by
my
the
lord.
consumer, my lord. I am not concerned with the borrower, my lord. I am the only purchaser, my lord.
16
Even
to
now,
before
in the
sale.
forfeiture notice, my lord, they have issued notice under 9 class 4, my lord. I am only seeking extension for 3 months, my lord, which is mandated in the statute itself, my lord. Rules 9 class 4. I am ready to pay the deposit, clear the arrears, my lord. But the pending litigation and by virtue of the order passed by your lordship, we are not, the bank was not directed to, the bank was directed not to confirm the sale for 4 weeks, my lord. Even then, I am seeking communication. My lord, kindly come.
Complete. I have to hear one advocate at
No,
least.
no, submission should not be wrong. There was no stay.
You can respond to that. Not that I am not hearing you.
Lord, kindly come to page number 29, my lord. All my reply or the communication
What
to the
is that you
bank,
want now?
my lord, 3 months of extension to pay the forfeiture amount of 75 lakhs, my lord. Kindly reconsider.
Why should they grant 3 months time to you?
My lord, due to the communication which I made by the pending litigation, my lord, on 12/3, I
There is
received,
no obligation on the bank to do it for 3 months.
my lord, section 9, rules 9
Yes,
plus
they
4 says so.
can, for the reasons for if they are satisfied.
My lord, that's what
So
I,
that
the
do not make
communication,
them, it's not obligatory on their part to do it.
please, my lord.
Now,
but-
when you are ready to pay the amount and you have participated in the auction, why do you want 90 days time?
my lord, because of the pending litigation and the court case,
Why are
because
you
in the
paying
writ-
it now? Pending litigation. Now, when the
my lord, in this writ petition, your lordships has asked the borrower to
pay
approach
it
TRT, my
immediately.
lord.
Now you are ready, you pay it immediately. I'll ask them to receive the amount. No 90 days.
No, because the order was passed on 17/3, my lord. Your lordship has given time to approach before DRT for the borrower, my lord.
So what you do if the
4
borrower
weeks.
approaches the DRT, you will not pay the amount.
Lord, I'm ready to pay them, my lord, because when the sale was not considered, then my,
If you make a statement that you're going to pay, I will record it.
please, my lord.
When are you going to pay? No, I will not say 90 days. No. You already had enough time.
My lord, the reason is that, my
Auction
lord,
was,
kindly see
auction
the,
was when in the month of February. March is over, April is over. You
Lord.
already have 60 days time.
my lord, the reason is that by virtue of this order, 4 weeks time was granted, my
The
lord.
council.
Even on 12/3.
You come up with the statement. When are you going to pay? That's it. No other things. I'll say condition to that. Otherwise, this holds good.
My lord, 60 days, my lord, 2 months.
With all this, you can't ask for 60
My lord,
days.
because, my lord, the order was passed on 7.
Now, today is 30th of April. You pay the amount by 30th of May, then it's fine. Otherwise, I am not going to do anything. Let them come up with their reply. Let them do it. Their objections. If you are ready, I'll pass on.
Please, my lord. 30, at least June 15th, my lord.
No.
15 days, my lord. I seek for 45 days.
Papa,
Only 15.
Because of
My lord,
the
my lord, because of this
litigation
pending,
between parties, you can't. No,
I am
when
well
you
within the limitation, my
when
lord.
you participated in the auction, you were ready with the amount. That is what is assumed.
Please, my lord, I am ready with the amount, my lord.
Why are you
But-
not paying them?
My lord, I have addressed the communication to the bank stating that there are, by virtue of this, because I was made party in this petition.
Forget about the litigation. If the litigation is not there, you are ready with the money or not?
Please, madam, I am ready with the money, my lord.
Then why do you want time?
Lord, that is what I sought by for the bank to see, seeking for communication, my lord. If they have sent any communication to me.
Either you pay the money, or because the litigation is pending, you don't want, seek for refund of the money. and go.
My lord, now
Only
the,
things.
now the borrower has not approached the DRT. I'm ready to purchase the property, my lord. I'm ready to purchase the property, my lord.
That's it.
I'll pay, please, my lord.
The petitioner has come before the court questioning the communication dated 12/3/2026, whereby the respondent bank has forfeited the amount paid by the petitioner. It is the facts of the case are that the auction had taken place on 17/2/2026 as per the notification issued by the bank. On 18/2, the petitioner has paid 25% of the amount, and on 19/2, a confirmation was sent to the petitioner. It is the case of the petitioner that on 28/2/2026, when he went to the on 19/2/2026, when he went to the 28/2/2026, when he went to the property, there a board. He saw a board in the said property that certain cases are pending. In that regard, he has addressed a letter to the bank on 28/2/26, 2/3/2026. It is submitted and but without considering all that, without replying to all that, the bank has issued a communication dated 3/3/2026 whereby they have forfeited the amount paid by the petitioner. It is submitted that, in fact, the borrower has approached this court by filing WP number 6558 of 2026, and this court by order dated 17 March 2026 has disposed of the writ petition, giving liberty to the petitioner borrower therein to avail the appropriate remedy before the DRT. It is submitted that in view of these facts and circumstances, he could not pay the amount. Land Council submits that if a reasonable type, as per Rule 9(4),
9(4), my lord.
9(4), the bank
With the
can
written
extend the claim
communication.
by 90 days. As such, the time may be extended. Petition may be granted time to pay the amount. Next part. Land Council appearing for the respondent bank submits that, in fact, the petitioner has not stated the correct facts before the court. When he has addressed a letter to the bank has replied to it by stating by attaching the order of the
National Consumer
Nation
State Consumer
State Consumer Forum. It is submitted that the petitioner has come before this court with suppression of material facts. Next para, having heard the counsels on either side, there is a material on record. The petitioner, when he has participated in the auction, when he knows the fact that he has to pay the amount within a time, that means he is ready with the amount. Now, what has been stated is with regard to the litigation. If the petitioner is not happy with the litigation and he doesn't want to go ahead with the auction, his remedy is to ask the bank to refund the amount which is paid by him. But in this case, the petitioner says he is ready to pay the amount. When once he is ready to go ahead with the auction, question of granting 90 days time as per 19(4) would not arise, as Section 9, Rule 19(4). 9(4). As per the same, if the bank is satisfied for the reasons, they may extend the time, and there is no obligation on the bank to extend it by 90 days, considering the facts and circumstances of the case and also the writ petition that is filed before the court. This court deems it appropriate to to give time to the petitioner for a period of 30 days from today. In that view of the matter,
My lord, may I seek for June? My lord, the notice is on 12/3, my lord. On 12/3, I was supposed to pay within 15 days, my lord. Then it will come to April 2nd, my lord. From that date, I am seeking the 30
90
days.
days I will not grant. That is what
90
I'm
days
saying.
from the date of action, my lord, not from the
That relates back to the date of auction.
date of action.
My lord, even that is considered, my lord. At least June 15th, my lord. I am well within the limitation, my lord.
Passing the following order.
My lord, at least June 15th, my lord. On 10 days seeking extension, my lord.
The order dated, the proceedings dated so and so, passed by the respondent, set aside. Number 2, the petitioner shall pay the amount by
My lord, at least June 10th, my lord.
5th of June, or else the respondent, the bank is at liberty to forfeit the amount that is paid by the petitioner.
June it will become 4 months, my lord. February was the action.
February.
June 5th.
1 minute. March,
April, May.
May.
May 90 days. Because it can't be beyond the.
My lord, notice is on 12/3, my lord. Notice
Notice
which
is different.
forfeiture
From the
notice.
date of auction, that 90
Action
days.
90
sir.
days. Because
My
it can't be
lord,
behind the
my
act.
lord, because due to this pending.
May 30th.
My lord, at least June 5th, my lord.
No, no.
Only 5 days, my lord, please, my lord.
May
May I request?
30th, yes, next.
Number, that matter moved.
Yes, there is that. Where is he?
The
Kartikeya.
morning move matter,
Yes. HDFC Bank. Where is Mr.
Kartikeyan,
Let's,
petitioner.
Sir,
my lord, some for the
morning,
petition.
To whom you have served?
For
Francis
Mr.
HDFC.
Xavier.
Yes.
Please inform him.
He told he served.
Call the matter next.
Ah.
Once he comes. Yes, next.
Cell number 15. This is Sitaram Rao for appellant.
Yes.
Lords, this is a case of death. Claim petition filed under Employees Compensation Act. We are challenging our liability, my lords, on the ground that the deceased was murdered and it is borne out in the police records. Yet, my lords, there is an award against the insurance company. We are the insurer of a car. Undisputedly, he was murdered. Yet there is an award.
Not proved murder. Who is the murderer in this case? Malaj is
Charge sheet
kind
is
of
filed.
charge.
Charge sheet is also filed. His wife also admitted.
That he is murdered.
What?
Saying that he is murdered.
Yes, my lords.
Kindly to trial court or judgment. Malaj is accident.
Court finding. If he is murdered, how are you entitled on a
Cha-
workman compensation act?
Charges says is a murder. Malaj is
Huh?
charge sheet is a column number 17 is there. Malaj is
It's a murder.
some. But trial court is observe that Malay is
Trial
is
court
a
can't
working
observe something contrary to the record after vacation.
Please.
Cell number 16, adjourned 17. Cell number 17.
Yes, Mr. Venkatesh.
Insurers appeal, my lord.
Hmm?
Insurers appeal, my lord.
Where is the counsel for the claimant? Yes, not there after vacation. Yes, 18.
Please.
Cell number 18. Cell number 18.
I appeal for respondent.
K.N. Harish Babu.
Nowadays, none of the matters, Mr. Krishnaswamy's appearance is, non-appearance is more. No representation for the petitioner.
My lord, I have a colleague who I think he is representing
also not
better
there
than me.
for-
He is better than me. That is the reason why.
Yes,
Cell,
after vacation.
cell number 19.
Also, the respondent is present, no representation on behalf of the petitioner after vacation. Then about 19,
19.
We will take up after vacation.
what is the point?
My lord, this is also with regard to the liability.
Hmm.
Anyhow, they want time.
No, what is the ground? No, if you can dismiss that, we don't have to grant time to them. What is the reason?
It is covered by the decision of this coordinate bench of this honorable court.
What is the issue?
My lord,
The claimant was the labor, loader and unloader in the tractor. He was sitting in the trailer and succumbed to the injury. And their claim is that
miscellaneous policy that was used for hire. Therefore, insurance company would not be liable. There is a statutory.
Like evidence is there to show that that is
Yes, yes.
used for commercial purpose?
Fact, that
Personal
is there in all the records that he was. But that is the
it's
reason
a
he is
package
taking
policy,
time.
my lords. It's a package policy and they have collected separate premium for the trailer also.
Not about that. Is it for personal agriculture use?
Please, in
or
the
commercial-
cross-examination, they themselves admit.
Agricultural and
Commercial use.
No, it's for agricultural purpose.
And what is the evidence to show that it is not for agriculture use?
Well, it is not for agriculture purpose. There is no evidence, my lords. But in the cross-examination, he admits that it was using for agriculture.
Oh, insurer admits.
Insurer, RW3, my lords.
I appeal that it was used for hire. Therefore, insurance.
No, it was used for agriculture purpose.
No, in fact, policy was used for is
Issued
issued
for
for
agriculture purpose.
agricultural purpose.
But used otherwise than that.
But it is used for hire. That is available with FIR and other documents.
After vacation, 20.
Cell number 20.
What about this?
Cell number 20. K.M. Venkatesh.
20. Waiting for the appellant, my lord.
What about this?
My lord, this is no nexus to death and injury, my lord. Death is after 1 year and 3 months.
Where is the respondent? After vacation, 21.
Cell number 21.
I am appearing for the appellant, my lord.
Venkatesh.
What about this?
Pawan Chandra
My lord,
Shetty.
this is
case where death occurred while traveling in the mudguard of the tractor, which I have insured, my lord. As per the decisions of this court, full bench of this court, mudguard passenger.
My lord, senior is out of station. Kindly have it on after vacation, my lord.
Yes.
Please.
22, 23 adjourned. Cell number 24. 24. 24.
Where is Mr. Jaiprakash?
R. Jaiprakash.
Upland. Not the.
He's not there.
Appellant is.
You're for the insurance company. You are for the insurance company.
Yes, sir.
On what ground you are before the court?
Tractor involved in the accident. I have filed the appeal on the ground that driver had no, it is now covered by the judgment of the Supreme Court in Mukundam case.
Mukundam case. Transport, non-transport?
Yes, there's no transport investment.
Give that.
It is covered.
Where is the finding?
You'll get it at judgment page 7, paragraph 12.
As per the principle laid down by so and so, light passenger carriage vehicle and light goods vehicle, driver who had valid driver, light motor vehicle, light goods vehicle, further tractor trailer was carrying simple firewood at the time so and so. And he cannot evade from the liability. Accordingly, he is liable to pay the compensation along with interest. What are you saying? No, you are held liable.
As per the Supreme Court judgment, I have no case. It's covered by the tractor. It is late motor vehicle. Therefore,
your appeal has to go.
Appeal.
The writ petition is filed. The appeal is filed by the insurance company, agreed by the award pass in MVC number 3809 of 2012. Both are arising out of the same accident. Both are arising, agreed by the award passed in MVC number 3809 of 2012 and 4570 of 2012. Two appeals, the appeals were filed by the insurance company. That is MFA number 656 of 2014 and 657 of 2014. In this, the tribunal has held the insurance company liable on the ground that observing that the driver was not having a valid driving license, as the vehicle is the driver who is having a valid driving license to drive a light motor vehicle cannot drive the tractor and is not having a license to drive that class of vehicle. Hence, insurance company is before this court. Land counsel appearing for the petition, insurance company does not dispute the fact that this issue is settled by the Honorable Apex Court as per the judgment in Mukund Devgan's case. In that view of the matter, Mukund Devgan's case, in that view of the matter, the appeal filed by the insurance company is dismissed. The amount in deposit shall be forthwith transferred to the tribunal. Both the appeals. Is 25?
Number 25. Sitaram Rao, BC.
I apologize, by oversight, cost title amendment has not been done.
After the petition shall carry out the necessary amendment to the appellant shall carry out the necessary amendment to the cost title.
Cell number 26. 26. Srinivas K.
After vacation. 27.
Cell number 27. Srinivasan M. Cell number 28.
28.
Sitaram Rao.
I have been unable. 27. After
27.
vacation. After vacation.
After vacation.
Please.
28. Sitaram Rao, BC.
Because we're challenging liability. It's a case of injury on the ground that there is no FIR filed at all. And a claim petition needs to FIR and wound certificate has to be filed along with the claim petition. That is the rule, my lords, under Karnataka Motor Vehicle Rules, Rule 32. That's not
filed.
complied. Yet, my lords, there is an award against us.
After vacation. Yes.
Cell number 29. Janardhan Reddy, P6.
Case of injury, but liability is fastened on the owner on the ground that the accident is involved between two-wheeler and tractor and trailer.
Accident?
Between two-wheeler and tractor and trailer. Trailer is not insured.
Mr. Janardhan Reddy was asking
Yeah,
for time. Yes. After vacation. Then 30.
Cell number 30, dismissal.
For respondent number 2 in this, please.
Gautam A.
That's for the petitioners.
Yes.
That's the matter pertains to.
You have questioned directing the second respondent to release the illegally seized vehicle bearing registration number KA3.
Please.
Who is the second respondent?
I'm for the second respondent. I don't have any objection for the allowing this petition, considering this prayer.
You are
and
the second
direct them.
respondent.
I'm the second respondent. It's in Eurofin Corp Finance Company.
What was the order passed on the last occasion?
The last occasion,
There was a direction for the state to file objections.
Filed?
It was filed. It was filed.
But
and
what he
notice-
says?
But we are not involved in this. We have never seized this vehicle, but only thing that after seizing the vehicle, the respondent number 2 has intimated us that the particular so-and-so vehicle was seized. That is because to prevent it that, the petitioner may come and file a complaint saying that his vehicle was theft. So preventing that, there was a request from the.
And he's
respondent.
ready to.
I'm not, we'll regularize the loan, we'll pay the.
No, he says no, he'll give it, he will.
Please, please.
We'll allow the
Direct them
Please,
to
please.
make the payment within the time frame of the, within 3 weeks, 4 weeks.
Yes,
Please.
within 4 weeks.
Only that state, the
They say
involvement of.
that, anyone, no, that we can't decide it. No, here, they say that they have not done anything.
Please,
By
please.
filing objection.
I just rely upon a Supreme Court judgment, Milots, ICICI Bank versus.
It's of no use unless and until there is material on record. The present writ petition is seeking the following prayer. It is a case of the petitioner that
And writ is
he
not
has availed,
maintainable. Writ itself is not maintainable.
because the only reason is your action is involved, otherwise it is not maintainable. The petitioner had availed the loan from the second respondent. The second respondent and he has been diligently paying the monthly maintenance. Due to from the last 5 months, owing to financial constraints, he could not pay the amount. On 18/10/2022, when the petitioner's employee had taken the vehicle in question for annual servicing, the second respondent representative has seized the vehicle. The petitioner's employee, upon instruction, stated that he is ready to pay the installment dues and to release the vehicle and the seizing charges. Later, they dragged the petitioner's employee to the Mahadevpura police station. And before the police, he has made the petitioner's employee to state that he has no objection for auctioning of the vehicle and force the petitioner's employee to write a letter to the sub-inspector of the first respondent police station. It is where did you question the action of the first respondent?
Please, Milots, I have at annexure 14 minutes.
Annexure 14. In your reverments, all through you're saying that you're aggrieved by second respondent action. Where is the first respondent action?
Please, Milots, paragraph 6 minutes. Paragraph 6.
You said so. Ultimately, prayer is against whom? Why would this court ask them to, our writ petition is maintainable?
Because the possession of the vehicle was taken forcibly by the first respondent.
Then you should, are you not supposed to question the action of the first respondent?
Please, please.
Where is the prayer against first
In
respondent?
prayer,
What matters is prayer, not your averments. What you can say 101 things in the writ petition, but ultimately in whom you are seeking the prayer is important.
Please, I'm not seeking any action against.
Please, what did you write? No, that's not like that. As stated, made him to state that he has no objection for auctioning of the vehicle and the forced the petitioner to write a letter to the sub-inspector of the first respondent police station. It is submitted that petition is agreed by the high-handed action of the respondents. When the matter came up on the last occasion, this court had directed the stationer's officer to file his objections before the court. Then an AGA appearing for the first respondent submits that they have never involved in this dispute and only the second respondent has addressed a letter to the petitioner with an anticipation that the petitioner may come to the first respondent, that they have seized the vehicle as they have failed to pay the loan amount as per the terms of the
contract
agreement. It is submitted that the writ petition is not maintainable if the petition is agreed with the action of the second respondent. His remedy is elsewhere, but he cannot invoke the jurisdiction of this court under 226 of the Constitution of India. Next para. Then counsel appearing for the second respondent submits that if the petitioner pays the outstanding amounts, they have no objection to release the vehicle, and has submitted, and he is also in the similar lines on. It is submitted that the writ petition is not maintained. What is that?
Is outstanding amount as on date of.
But I will not say anything. And if the amount is paid, they are ready to release the vehicle.
Subject.
Having heard the counsels on either side, there is a material on record. Though in the writ petition, the petitioner has made an amendment stating that the police have acted in a high-handed manner when it comes to the prayer. Absolutely, there is no relief that is sought against the petitioner, against the first petitioner, that is the stationer's officer. Then coming to the other reliefs that he is seeking against the second respondent. For those reliefs, a writ petition before this court is not maintainable. However, the second respondent is submitted that he is ready to deliver back portion of the property provided the amounts are paid, that the outstanding amounts are paid. It is between the petitioner and the second respondent that this court cannot pass any order against the second respondent, as he is not a state as per Article 226 of the. He is not a state as per Article 12 of the Constitution of India. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to initiate appropriate proceedings against the second respondent.
If I may, 226 against a private individual who does not follow the procedure established by law is maintainable. I rely upon the Supreme Court judgment.
That also he relied on, the land council has relied on the judgment of the court in ICICI Bank Limited, versus Prashant Kaur and others, wherein the court held that the bank should resort to procedure recognized by law to take possession of vehicle in case where borrower has committed default, instead of resorting to strong arm tactics. Even on that count also, in the operative portion, if the petitioner is aggrieved by the high-handed action of the respondents, he would approach the police by giving a suitable complaint. Admittedly, in this case, no such complaint is given. Yes.
Matter moved. Applicant, Karna.
Yes, you have instructions, Mr. Judge.
Yes,
My lords, I am for the petitioner.
Yes, my lord.
My lords,
What is the relief you are seeking? Come to the relief.
my lords, to restrain, my lords.
Requires the order dated passed by the chief. How are you concerned with this order before this court? Why this court should interfere to restrain any enforcement action under SARFAESI Act? Why?
My lords,
What are the reasons?
My lords, the default was for insurance premium, my lords, not for loan. They have admitted, my lords.
What is that?
Well, kindly take annexure L, my ink page
My
number
lords, may
60.
kindly,
Page
One
number?
second, sir.
Ultimately, let him say that when you want an interim order, isn't it?
Yes, ma'am.
So I have to understand.
He has
from-
taken two loans.
Hmm.
One loan is 28 lakhs 26,000, which has been reflected in the notice issued under section 13(2) of the SARFAESI Act. Another loan is 98,873,
That is the insurance loan.
which is towards the insurance premium. My lord, I will take to ink page number 47, annexure D.
Hmm.
Annexure D. My lord, the loan is covered with the insurance. My lord, there is a mail to them. HDFC Ergo Insurance Company, it is a separate entity. Whatever the loan which has taken towards the insurance premium has been remitted to the HDFC Ergo, and HDFC Ergo issued insurance policy insurance to the borrower. My lord, mail has been communicated on 33/2021. Policy number with all the details. 33/2021. To till today, he has not raised any dispute. He paid several few EMIs towards the insurance premium. My lord, all of a sudden he has come before the bank and stating that I have not given consent.
I have not.
I have not given the consent to take insurance policy, all those things. My lord, kindly I will take my lord to the bank response.
The outstanding amount as on today.
My lord, the outstanding amount as on today,
Did he reply to your 13(2) notice?
no. He could have replied, that is my concern.
we have replied, we have represented, my lords. We have
Please tell the court, when is the 13(2) notice you have received? 13(2) notice, when was received by you?
13(2) notice, my lords.
I will tell the date. 31/10/2025.
31/20/25 was the 13(2) notice.
Yes, ma'am.
When was your representation?
2025. Our representation was on it's 24/1/2026, my lords.
Why, how can you give a reply to a notice in 25, in 26?
My lord, even HDFC Ergo is not a party. His concern is that, my lord, HDFC.
Him say, no, they have issued a notice under 13(2). You are agreed by it.
Yes, ma'am.
Are you not supposed to give a reply?
Yes, ma'am.
In turn, they have to respond to the same.
Yes, ma'am.
Without doing anything, you keep quiet and tell something to this court, which the court cannot appreciate. Go before the DRT and question all this. The present petition is filed.
My lords, but the loan, the default
Whatever
was
it
in.
is, that you have to do it at the 13(2) stage, not now. The writ petition is filed. Sing the following prayer. The bank, it is a case of the petitioner that the loan now that they are going to recover under SARFAESI proceeding is in respect of an insurance policy. Hence, it is submitted that the respondent bank has no authority to initiate the proceedings. Then counsel appearing for the respondent bank submits that 13(2) notice is given on 31/2025. And from there on, for that, the petitioner has not given any reply to the same. And the bank has proceeded with the further proceedings. It is submitted that under the act, under the SARFAESI Act, if the petitioner is agreed by any of the steps taken by the bank, he has a remedy before the tribunal under section 17 of the act, and the writ petition is not, he cannot come before this court when there is an effective alternative remedy. Next para. Then comes in response to that, then counsel for the petition submits that he has given a reply on 24/1/2026. Next para. Having other counsels on either side, peruse the material on record. It is a case of the petitioner that the particular loan, the amount is pertaining to an insurance policy, and they cannot initiate the SARFAESI proceedings. The bank has initiated the proceedings under 13(2) on 31/2025. If the petitioner had any objection to that, he would have given a reply. The reply that is stated to be given on 24/1/2026 cannot be considered as a reply to the 13(2) notice. As per the act, he has to reply to the same within 60 days.
60 days.
60 days from the date of receipt of the same. In these circumstances, this court cannot go into all these aspects. That apart, there is a remedy available to the petitioner before there is an effective alternative remedy to the petitioner under section 17 of the SARFAESI Act. Even on that count also, this court cannot entertain this writ petition. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT within a period of 30 days from the date of receipt of the copy of the order in accordance with law.
My lords, there is a submission, my lords. They have clubbed both the loans together.
What I'm saying, what happens is when they issued a 13-2 notice, you have to reply to that. You are not, it is not open for you to raise all these grounds now. So that's why we can't consider. If you have something else, you have to go before the tribunal, the second step.
My lords, but the vacation notice is on 2/5, my lords.
No, we can't interfere with that.
The petitioner has never defaulted the home
That's
loan.
why
my
I
lord.
go before the DRT. I gave you time. Question it before the DRT.
Please.
Lordship, a small submission to make. Small submission to make. On Saturday, in the Kingfisher Airlines matter ಅಲ್ಲಿ, senior counsel Sajjam Poyar submission ಮಾಡಿದ್ರು. We have filed our written submission in the office.
Yes. They'll send you resolved matter.
Court has directed to file a written submission.
Yes,
So
yes,
we
yes.
have.
It will come.
What up, sir, madam? What up, sir? Sir? Madam?
ಇಲ್ಲಿತ್ತದು ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ 23 ಒಂದಿತ್ತು ಮೇಡಮ್, ಏನಾಯ್ತು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ MFA ತುಂಬಾ.
Okay.